this right here in the corner for a minute?
You can do whatever you want. I will.
Are you packing your stuff up and leaving? You had enough?
What's
You're
that?
done? You're packing up and leaving?
Oh man, no! I just moved my computer out of here to make more space for everybody. See, I don't. This is my. I still think I'm a student, so I always bring a notepad.
Nothing wrong with that.
You know I'm right.
You know,
I'm the queen of CYA, you know that?
I've learned so much from that now.
Hey,
When I met you all them years ago, I thought, oh, she's a little over.
Hey.
No, she's not over at all. She's right on
No.
point, right on point.
But you want me to get a hand?
No, we're okay. I can stay.
I know we see each other a couple times. We've talked a couple times, but I don't think we've had cases together.
I work for the city of Henderson right now. Most of my litigation is on my first responders and their GGR
Oh, that's
Henderson
yours.
hate. Yeah.
Oh, Henderson Hate too? I didn't
Oh
know.
yeah,
All right.
because
Who's the attorney there?
Sean Moena.
Oh, Sean Moena?
Yeah. So,
I know the name. I don't think
Used to be a Henderson hate. He just went off on his
That
own.
would be awesome.
oh, he wasn't Henderson hate. That's who did most of the stuff for my
beginning?
PD. I didn't know he went off on his own.
Just a few months ago.
Oh, okay.
Everybody online,
Supposed to
can you
go out
please
with him next week. He's a good friend.
It's already nice to us now.
I don't know how this is going to work. I guess you can hear me that way. Huh, amazing.
Attorney Ferguson, can you please mute? Actually, you know what, I'm just gonna.
Are we all good?
Why do we still hear you? Oh, Trish, remember last time? Well, did you pick up those things off the ground?
I like how you do that. Dalton just pointed to it. Make it stop.
Oh, the echo. You need to mute that on the dash.
It's muted on here.
No. Here you go.
Okay, talk? Nope.
Is that better?
Do we need this on?
What's it for? I don't know nothing.
Sharing a screen for any kind of information, we're just talking?
I spent the last 10 months trying to set up my iPhone. I got a work iPhone. I can't get serious. It gets me in October and I'm still fighting with it.
No, I didn't, but I can do it right now. I can share a screen. Yeah.
Are we good? Okay, hey y'all. Nice to have you. And for those of you that showed up, right on, thank you so very much. For you guys online, we so appreciate it. Make sure if you're an adjuster that you do have your license number and stuff so that the ladies can make sure you get credit for your CEUs. Welcome to NDPC. Thank you for attending. Those of you who are online will be muted. If you have questions, please use the raise hand function and we will call on you. We have disabled the chat feature at this moment. There are
No, I
times.
think it is actually open.
Is it?
It's open, yeah.
Oh,
Sorry.
my notes are wrong,
I'm sorry,
so
I
it is
apologize.
correct. The chat is open. Of course, what we do ask with the chat is that you be kind. You know the problems in the past that sometimes are sarcasm, and we all know, and sarcastic. So sometimes the sarcasm gets painful for other people. So just be kind. If you think it's funny, it might not be, so don't write it. If you have questions, though, please step up, ask the questions. Those of you in person, if you have questions, let me know. I'll acknowledge you, I'll see you, I'll look at you, and then I'll get it back to you as quick as I can. I will hand the mic to you, but I'm not real sure. I might hand you this big old mic, I'm not real sure. And that way, so that everybody online can hear you also. I always want to thank the board members. NDPC, you guys all know this is a nonprofit organization run by volunteers, run by amazing individuals. Our board currently, president is Christy Bybee, our vice president is Trish Gibson, secretary is Catherine Nelson, and I always say God bless her because that's a horrible job. And treasury is Sean Ellis. Our directors are Sue Hare, Nicole Marley, Veruska Corso, Dalton Hooks, Trudy Johnson, Kevin Campshire, Kevin Depachard. Was I close?
Debbie Parshall.
Debbie Parshall.
I'm gonna get that, sir, I swear. Miguel Delgado and Linda Lee. Don't forget to always go to our website to look at the future events and the important information. We are constantly working on our website, like everybody else in the world, to upgrade it to keep it current. We appreciate you guys if you go there. If you are a member, we are developing the member section, so there are additional benefits that are set aside for you also. And the way it says here is if you go to the member portal, you go to the home page and register for it, it'll send you a link, and then you can get added to it, and that way you have past lectures and stuff like that that you can look at. Membership is via the website. We have the membership here if you want to check it out. Again, in order to get the CEUs, you have to be a member. You can always attend, you can always listen. But to get the credits, you have to be a member. We always want to thank Water District. It's so nice to be back for a moment. Not that I don't mind the other places we go. I so appreciate it, but this is a lovely facility, and we appreciate it. I don't see Sandy in here, but
She's not here today.
she's ditching us?
Yeah,
Gosh, everybody is.
she had meetings.
Well, bless her heart. It is an open forum. This particular topic of IMEs, there's lots of questions on it. If you don't understand, please ask. Because I found that in our conversations in the last couple of weeks talking about that, it's misinformation. A lot of people just don't understand. There are so many ways to apply this topic. People don't understand it. Now, these people understand it up front, but this is going to help us understand when to apply it and how to apply it and why do we use the IMEs.
Tyrion, I'm not dealing with you all day.
Ooh, Nicole Marley.
Oh. That was great. I was like, whoa, whoa.
My dog, it's her dog, not her kid.
I was like, wait, this is hard shit. That was good.
I was like, oh, I'm not going to be one of Nicole's kids. Holy cow.
Let's just do a reminder, can everybody mute online, please?
And check to make sure you muted. Don't assume you are.
That was just a little pre-planned vignette.
Yeah. That was for her to
This
get
could
it
be
out.
you.
Get it out now.
This could be you.
That's exactly right. I'm going to,
I'm probably never going to live that down.
no, no, never. And neither is TT. I'm going to go down and start with Dalton. I'm going to let these guys introduce themselves because, you know, they are phenomenal. And I think it's important that you guys recognize that when we pick our panelists or when we go out after it, we truly look for the individuals that can provide us the most information as well as who understands what each of us does every day. So Dalton, where'd you come from?
Wow. So, Memphis, Tennessee. Constance
Oh,
is my mom.
see?
Dalton is my dad.
My
so-
heart, my heart.
Anyhow, so I'm Dalton Hooks. I'm the founder of Hooks, Bang & Clement. We're an insurance defense or primary work comp defense law firm. And I've been doing workers' comp in Nevada since 1989 when I started at State Industrial Insurance System. Then went to Nevada OSHA.
SIS stands for?
Then I went to
I think this will hear you too.
Yeah, I
just
think
wanna
it's,
make sure.
yeah. So then I went to Nevada OSHA for some years, and then I went to law school and became a lawyer, practicing since 2002.
We're so glad you did. Well, at least
My
I am.
next, good morning, I guess, everyone. My name is Thomas Kuchera. I'm a practicing anesthesiologist and pain medicine physician. I've been practicing in Nevada for 8 years, taking care of injured workers the whole time. I'm originally from Ureski, Czechoslovakia, if anyone wants to name that you can't pronounce. I've enjoyed my practice. I've been off on my own for the past 2.5 years in a solo practice.
And we appreciate that greatly. Thank you so much for being here. Senor.
Hi, I'm Carol Banks. I am with the City of Henderson. I'm currently their Workers' Comp Program Coordinator. I oversee their self-insured workers' compensation program and the heart-lung program for our first responders. I have over 33 years in work comp experience. I've handled it on the TPA side, insured side, self-insured, self-administered. I also handle lots of lines of business, multiple jurisdictions, as well as Jones Act and longshore claims. And I've been in handling Nevada work comp claims for over 16 years.
That's amazing. And you're brilliant.
So my name is Miguel Delgado. I am an attorney, let's call it founder, like Mr. Hooks, the founder of Delgado Injury Law. I am from Cuba. I've been here for about 19 years. A funny fact, in 1989, when Mr. Hooks started practicing workers' comp, I was 4 years old.
In fairness, I was 19.
I've been involved in the workers' comp arena since 2016 when I started clerking for Nevada Attorney for Injured Workers. After passing the bar, I went to work for a great firm where I was tasked with building a workers' comp department. And after I did that for a while, I decided that I wanted to do it for myself. So in 2021, we went ahead and opened the Delgado Injury Law. We mainly do workers' compensation. We specialize in Nevada workers' compensation because of my where I come from. About 70–80% of my clientele is Spanish speaking. We try to serve our clients with passion, and we try to be respectful to all parties. And I'm here to learn from all of you too.
Well, thank you very much. Appreciate that. I'll move that a little bit back. So what we're going to start with is the when do you use an IME? And with that, for those of you, do the online people, did they get a handout? Do they have this?
Yes, everybody has the agenda, and I just sent out Miguel's copy of his statutes.
Okay.
Statutes. So that went out to everybody. It's on your email. I don't have them printed here, but everybody has it on their email.
So when you guys, at this beginning of part, when we start running through these NRSs, that you'll have it printed in your email. So make sure that you go to that or jot them down. Because, again, you know, I have immense admiration for Carol. She's amazing. And one of the things that we constantly say, and I always love it, is we did not provide you the printouts of the NRSs because we want you to read them. We want you to read your NRSs, and like I've said before, read them at least once a year. They change all the time, so read them. So let's start with, when do you use an MRE, an IME, and it starts with NRS 616C 140. Do you want to do the same thing? You want to start with Dalton or Miguel?
Miguel's gonna, since he's got the statutes there, he's gonna take lead. I'm gonna
You're going to fill in?
back
Sure.
clean up.
Outstanding.
Okay,
I like his accent.
Okay. That's strike one. Okay. So we're going to be talking about independent medical examinations. There are two main statutory rights to do independent medical examinations. One that is provided to the defense, to the adjuster, to the employer, and another one that is provided to the injured employee and the representative. So we're going to be talking initially about the rights of the employer, the adjusters, to conduct an independent medical examination. And on this one, I have heard from Ann before and from a lot of folks that we're kind of in need of guidance because the IMEs are something, especially the 145s, it's something fairly new in our state. It's only been 145 since I believe it's 2017. And the feedback that I hear from adjusters is, oh, you always want an IME for everything. Like, what's going on? Right, so I'm trying to bring some, basically, I'm trying, by going through the statutes, to understand when folks can use them, for what purpose they can use it, and so on and so forth. I know that there are questions. I don't have your guidance as to whether the questions are going to be asked at the end of each section?
We do
or?
open.
Okay.
I have ADHD. I can't wait
All
till
right.
the end. So,
Okay.
yeah, so
Sure.
Christy will monitor on a chat page, and then they'll just speak up and we'll call them out.
Okay, so,
They lost audio.
They lost audio, Christy?
Okay. That's what we told them. So hang tight.
Excellent. So the purpose of this meeting is not to give legal advice or talk about specific issues that you're encountering. For that, I encourage you to reach out to your attorney. You have some of the best work comp attorneys in the city. When I go against Mr. Hooks or Dan Swartz, it's always a win for me because I either win or I learn. And when I learn, I always win too, because it makes my practice better. So these guys are some of the best. Reach out to your attorneys. It is possible that we will disagree during this presentation about a couple different things. I will try my best to do it in a respectful manner, and I hope we all do the same. Many of these provisions are new, like we talked about it. Some of it is untested. Like there's going to be a point as we dive into the granular aspect of the provisions that we're going to probably disagree on a couple different things because this is untested. All we can do is present our arguments to the courts and let the chips fall where they may, like I say.
Yeah,
So-
let me just jump in with a little bit of foundation. So, again, this section is, this section is labeled, when, I think this is more as what is an IME, where does this right come from, as Miguel stated, there's really two pathways. 140 deals with the employer, the insurer, and the appeals or hearings officer's right to request an IME or to demand an IME. And 145, as Miguel mentioned, is newer, and this is in response to when this was added to the law 2017, mostly through the work of the NJA, specifically Jason Mills. The idea was that we were in a situation that they believed was unfair, where we could have the claimant sit for an independent medical evaluation, and for claimants who were injured, no money, they had no ability to get a follow-up opinion to challenge that so that they could present their case, given that they have the burden to present all of the evidence necessary to support anything that they want under the Act. And so that was the genesis of 145. For those of you who sat through the legislative update that we did after the last session, what Miguel is also mentioning is that there are changes to NRS 616C 145 that he's going to go over that we'll talk about that are the law as we sit today, but are not on the website for the state of Nevada because they're not fully codified, which means written into the statutes. So if you're looking for this, as Ann mentioned, you're going to need to pull the AB's 274, or actually SB 274, in order to see what that law says. We're going to cover it a little bit. Miguel's going to get into that. But first, we're going to start with 140, which for the adjusters in the room, that's our bread and butter in terms of doing a medical examination. But if you look at the statute, and I want to turn this back over to Miguel, it is specifically for the insurer, the employer, or the trier of fact, whether that be the appeals officer or the hearings officer. So work comp is a triumvirate. You got the claimant, you got the employer, and you have the insurer or administrator. All three of those individuals ultimately have a right to demand an IME under the right circumstances. And we'll have Miguel take you through the law.
That is correct. And if you want to follow along, we have posted the text of the language of the statute in its entirety, NRS 616C 140. You can look it up as well in Google, but I think Chrissy has posted it on our chat as we go through it. So as you can see, this is NRS 616C 140. This is the rights of the adjuster and the employer to conduct an IME under certain circumstances. And as you can see, Mr. Hooks does not need notes. He's been doing it for, since I was 4. He doesn't need notes, but I do have some. I do have some notes.
Back to that, huh?
Hey, if Nicole's not living it down
I
here
thought we were going to try to get along today, Miguel.
So I do have some notes that I'll follow along, but if there are questions, refer to Ann on the questions, things like that. So I want to go to subsection 1 or NRS 616C140, and the text states the following: an employee who is entitled to receive compensation under our act, under the Nevada Workers' Compensation Act, shall, that means it must, if requested by the insurer, the employer, or ordered by the appeals officer. So this is telling us who can request the injured employee to submit to an IME, as Dalton stated, right? It could be the insurer, the employer, or the appeals or hearing officer. So the injured employee shall submit to a medical examination at a time and from time to time at a place reasonably convenient for the employee, and as it may be provided by the regulation of the division. So there's a lot of words here that we need to understand what they mean. And the first portion of this is that the statute is sending us to a regulation. So we need to look at a regulation to clarify what is reasonably convenient, what from time to time means, and things like that. And if you want to know what regulation refers to that, that would be NAC 616C 1162. Notice the difference between NRS and NAC. NRS are statutes, and NAC are regulations. So they are different. This is not correct, but in my mind, I usually tell myself the statutes tell us what, and the regulations usually tell us how to do things. Right? This is not correct, but that's what I tell myself.
Excuse me 1 second. For those of you who have not seen the invite yet, it's going to be in your email, not in the invite. So keep watching your email, because they're saying they haven't got the handout.
Oh, I just emailed it to everybody. So.
Right. So
And I'm putting them on the chat line as well.
right. So just be a little patient. It's coming. Thank you, Migo.
So speaking about the how to request and how to go about requesting this 140 independent medical examination, if you refer to the regulation, you'll see a few words that are of importance. For example, the insurer or employer, if they request an injured employee who has filed a claim for compensation to submit to a medical examination pursuant to the statute, so it's bringing us back to the particular statute, it shall do that. It shall notify the injured employee in writing, so no text messages. Or is it text message in writing? Let's fight about it, okay? So in writing, okay, at the time and place of the medical examination. And then under the regulation, under 1A, it says at least 10 days before the date of the medical examination. This is where the 10-day rules comes from. At least 10 days if the injured employee resides within the state in which the medical examination will be conducted. So if it lives in Nevada, if the injured employee resides in Nevada and the examination will be here in Nevada, 10 days. Is this 10 business days or 10 days? Let's fight about it too.
Well,
It's-
it's actually neither, because what we have, that's right, it's
21.
21 days now, pursuant to.
To the new,
The new reg.
okay,
Correct.
to the new reg.
Unless the parties agree that it would be sooner. And that comes out of, I want to say AB, not sure if it's AB or SB, but it's 244 from the last session. And this is a bill that we talked about in the legislative update, which is
So this is something else that needs to be
passively
updated.
has
Yes.
nothing to do with workers' comp, because it isn't a workers' comp bill. Trish?
The 21 days is a really long period of time, and I think a lot of the adjusters are not comfortable asking the attorneys. Maybe Miguel and you yourself can advise, because they'll call me and I'll say, well, the doctor's available this date. Well, that's too short of a time frame. If it's really important, the attorney also will probably want it to be done sooner. That making that phone call to resolve it and to get it done quicker is sometimes very easy. And I don't know that all the adjusters, especially the newer ones, are comfortable doing that. But a lot of the time, it works out because the doctor is, going to be available quicker and to resolve things. So just.
Well, I would
Okay,
say
so
get comfortable with it.
I'm gonna follow up for you guys. If you're online and couldn't hear what Trish says, Trish said that 21 days is a long time, and that's true. One of the points she made, though, is that the adjusters aren't comfortable in having a communication. One of the things that I have to influence, I have to say to you guys, if you do not, as adjusters, start picking the phone up and talking to people, then you will be replaced by AI. Because that's the only difference between you and AI, is the fact that you pick the phone up, you talk to them, and you are able to do that. So if you are somebody who just wants to type, then it's coming for you. For the rest of us who love to talk, um, you have to call. And it is not inappropriate for you to call the injured worker, or if they're represented, call the attorney and say, look, Trish says I can get him in 7 days. Is that cool? They say yes. Make sure it's in writing. Make sure they follow up with that conversation in writing. It does not count by you sending them an email that says, hey, just confirming you said 21. You telling them 21 or 7 is not going to work. You have to say, hey, yes, we all agree. Send me that you agree with me. Because when you get audited, you need to be able to establish that. 21 days is the time frame. So it doesn't matter when the doctor's available, doesn't matter when you need it done, none of that. 21 days. If you get it accepted, and an exception to that, get it in writing.
Yeah, so just to put a finer point on this, as I said, if you're not comfortable, you need to get comfortable, because here's the consequences. 140 allows you, as an adjuster, administrative claim, to compel the claimant to go to the IME. If they don't, you shut off benefits, right? So let's say you do that and you scheduled it for 10 days out. You've got several problems. Number one, 21 days. You shut off benefits, you're now looking at the regular stuff, DIR, potentially a benefit penalty, but also under, and it is AB 244 if you want to look it up from this session. You, by violating the claimant's entitlement to 21 days notice, have now violated that statute, which subjects you personally to being sued and subject to a $1,500 fine or costs, whichever is greater. It's no joke. You've got to get this right. So it's 21 days. It has not been made into the statute yet. The DIR is working on those changes. So coming to these presentations, especially the legislative update, getting that information wherever you do it, whether folks have me come out to their facilities directly and train their team, come to one of these or other sessions that are available for you, you have to know this stuff. Right now, it's taking an unusually long time for this to get codified. It's usually about 6 months maximum. It isn't there yet. So if you don't know, you don't know.
Yeah.
That's bad.
Okay.
Well, I just wanted to reiterate the fact that, as Tricia stated, some of these adjusters are not comfortable reaching out and contacting the claimant attorney. That is to your detriment. A lot of things can be resolved with relationships with the claimant attorney so that you don't even have to go down the path of an IME or go down the path of litigation or go down a path where you don't get your situations resolved. You need to build relationships on all sides of the house with the employee, with the injured workers, attorney, with their supervisor, with the defense attorney. And so just as, Ann had stated, AI can replace, automatic functions, but those relationships are what help move your claim. So, reaching out, I have great relationships with my claimant attorneys as well as my defense attorneys, and that's what helps to keep the claim moving. And so you've got to let go of that apprehension and put that out there.
Outstanding. Okay, back to you.
Somebody online's asking, of course, Nicole Marley agreed to call the office, have the attorney waive it. Otherwise, they're waiting close to a month. But somebody's asking what the statute is for that benefit penalty.
It's not codified. So you are going to have to look up AB 244 from the last legislative session.
44. 244.
That's Assembly Bill 244 from the, I think it was the 83rd
No problem. Chrissy,
legislative.
you guys have the packet from the legislative session.
Oh, if you are a member, you can also go to the members portal where there's a packet of all of the legislative, and it includes the 244. Thank you.
I was just going to say, and if you're an adjuster, not only do you want to look at the DIR's website, but you also want to look at the legislative website. That's
Amen.
where you'll have access to all of the bills that were proposed. You could see the revisions. You can see how they're adopted. So, if you want to be a leader, you got to be a reader. So you have to get familiar not only with the DIR, but with the legislative or the Nellis branch that's out there, so you can stay on top of things. You can even track bills yourself if they have an interest to you. Oftentimes I have a burning desire to track certain bills so that you can get notice to know how it progresses. But that's a responsibility for your professional enrichment and just to make sure that you're doing what you're supposed to be doing when it comes to handling claims.
And just to be clear, on this issue, I don't think Miguel or most of the claimants counsel on the other side are really going to want this to push out to 21 days. Again, this law was not written for us, however, and we tried to have us expressly excluded. That wasn't possible, so it applies. But I don't think that anybody should be concerned about reaching out to the other side saying, I want to schedule this according to the old statute for the 10 days, because it's in everybody's interest. The entire point of the work comp system is to avoid all the stuff that goes along with district court, which is what this was for, right? This is a district court related problem that they were trying to fix that has now caught us up in, not necessarily unintended consequences,
But unintended consequences.
right. So,
As you anticipated, the $1,500 comment has kind of tripped some people out.
that was kind of the point.
And that's exactly right. That's a $1,500 to you, the adjuster who made the mistake. Not to your employer, not to the carrier, not to Santa Claus. It's to you. Because again, you are a professional who is licensed. And that's the difference between today and 1980. Back to Miguel.
Somebody online saying we don't have to move the microphone, everybody can hear us.
God bless you, whoever said that.
Yeah, Terry, yes.
Terry, I love you. Thank you. I'm a poor Vanna.
So we'll just move it in the middle, huh? Is that good? Yeah?
Put it, yeah. Oh, I'm so happy.
Yes.
Well, to get back to it, I did not purposely give you the wrong information. I looked it up at the at the regulation, is still not updated there. But for the record, if you're keeping track and you want to do your job correctly as of what the law is now, it's 21 days, okay? So just to be on just so we're all clear on that. And the old provision says that if the injured worker lives out of the state, then you give them 15 days, but I assume it's 21 days now for everybody, right?
21
So just
trumps everything else.
so we can be on the same page.
Blackjack.
Just what include PT appointments?
Say that again.
Somebody online asked if that includes PT appointments.
This is for independent medical examination
IMEs only.
ordered by the
No, it's not.
by the
it's-
insurer.
We're talking about IMEs only here.
Yeah.
The 21 days applies to physician's appointments, consults, second opinions, and IMEs.
There you
It
go.
applies to all compelled examinations.
Compelled.
So again, it has nothing to do with workers' comp, but under workers' comp, the compelled examinations include IMEs,
PPD.
PPD appointments.
PPDs, potential, yes. So anything where, I think, I like the formulation that Jason Mills gave, which is any doctor's appointment that doesn't form a client-patient relationship is going to be covered under this, because it's something that they're required to do. The way that the AB 244 is mentioned, it's any examination that they're compelled to do because of operation of law, contract, anything where they don't have a choice. Okay? So it'll be broader than just the IMEs, but we do need to focus on IMEs today.
Thank you. Back to you, Miguel.
So we're still on the regulation, NAC 616C 1162. Here's another thing we need to do, other than provide the 21 days. The statute says that an insurer that requests an injured employee to submit a medical examination pursuant to NRS 616C 140, the provision that we're talking about, the statute we're talking about, shall provide a copy of the written notification required pursuant to the section to the employer of the injured employee at the same time at which the written notification is provided to the injured employee. So at the same time as we send a notice to the injured employee for the, hey, you must be at this place at this time for an examination, the statute says you shall provide it to the employer. As I was going through this, I wonder why this would be, and it hit me because I have quite a few, I represent more than 300 injured employees. Sometimes when they get a notice such as this, they ask their employer for permission to go to the appointment, the employer says no. So I strongly believe that if we're all doing what we're supposed to do, if we send a copy to the employer is more likely to allow for that time off so the injured employee can present to the examination, as opposed to the employer thinking that, well, you're making it up, you just want a couple of hours off, or something like that. So the regulation says that you are supposed to provide a copy of that notice in writing to the employer when you request that examination. Any questions on subsection 1?
Online, they're asking for clarification. Can we get clarification, so what prompts the fine to the adjuster? The termination of benefits for not attending an appointment if said appointment is not scheduled 21 days out, or merely scheduling an appointment less than 21 days out?
Okay. So, the law under AB 244 gives the examinee, because it's not just for workers' comp, so it's not just claimants. It could be a defendant in a lawsuit, plaintiff in a lawsuit. Whoever the examinee is, in our context, we're talking about the claimant, has several rights. One, they can record it. They can have a representative there. They have to have 21 days notice, et cetera. There's more. I'm not going to go into all of it. A person who infringes upon one of those rights is subject to the fine and being sued. So that is the adjuster, and the triggering event is, in this context, scheduling the exam in less than 21 days. So that is the offense. What I said about, if you were then to, again, this is an unlikely scenario that anybody on this, either in this room or on this call, is going to do. But some unaware adjuster thinking that it's 10 days, shutting the claim down, and saying, I'm not going to reinstate benefits, which is the lever that you have until you submit to this IME, would, by virtue of scheduling it in less than 21 days, be subject to AB 244, and by cutting off benefits wrongly, be subject to benefit penalties, fines from the DIR.
So what if an adjuster either puts it in writing or something that says, we can schedule your IME 21 days out, or if you would like, we can schedule you earlier. If the patient says okay, then they can't be fined, right?
Well, that's what we've been talking about.
So
You can
you just-
agree, the parties can
You just have to
otherwise
agree.
agree to shorten the time.
But
In
How
if
you
an
do it-
adjuster schedules an
writing.
IME or
In
something
writing.
less
In-
than 21 days with nothing in writing, they could be,
They will be.
Subject.
they will be. They
Subject.
will be. So
Subject
don't
to.
schedule less than 21 days, unless you have it in writing that they approve,
Correct.
Correct.
all the parties.
But we
Right.
don't want to scare them to not want to do it sooner.
No, we want you to do it sooner. You will want to do it sooner. They're not, again, Miguel can speak to this. Miguel, you're going to have a problem if somebody calls you up and says, hey, I want to schedule this IME
Absolutely
10
not.
days out. Right.
It is your right, so absolutely not.
But here's the other thing, if you call them, and let's say for some reason, Miguel it doesn't work for him, and he says no, no is no.
Correct.
No, yeah, well, yeah.
No is no, 21
Dalton?
days.
Yes.
Can you confirm that if we are scheduling a transfer of care with intent to form the client-doctor relationship, this 21 days would not apply?
A transfer of care is not a compelled examination.
Okay, but they still have to wait 21 days, they're just not subject to the $1,500 fine.
No. You're not subject to the bill unless it's a compelled examination.
Outstanding.
A transfer of care generally is going to be something that's coming at the request of the claimant.
Right.
And already agreed to probably.
Now, if it is, we're transferring care, so let's be clear, if you're transferring care to establish a new treating physician, and this is something that we're doing on our own because for whatever reason, don't like the doctor isn't qualified,
Dr.
there may
Bradley's off the
be
list.
a gray line there. If you're forcing, if either the act forces or you are forcing, again, think about it in this context. Is this a compelled examination? Are you in a situation where if the claimant doesn't go, you're going to shut off benefits, or at least that's the potential tool for you? Then that's compelled, and you may want to look at it. So in most cases, I'll give a better answer. In most cases, under a transfer of care, no. some cases, maybe. And it's not, look,
That's super clear, Dalton, thanks.
I'm a lawyer.
It
This
depends.
is the law.
It depends.
It depends on the
depends.
relationship.
It does. And to be clear, this is a brand-new law that isn't even on the books. It is the law now. It was the law upon signing, or upon
Right.
passage, right? So that was last June. However, how it's going to work and what all of the little wrinkles are gets sorted out over time, and after they print it in the statutes will be an important change.
I can talk loud enough.
Yeah, you and me both, buddy, don't worry.
So for transfer of care appointments, if they don't show, all we can do is just send a 10-day versus scheduling a 21-day notice that you have to show. If they don't, and we sent the transfer of care letter, a 10-day notice would suffice as well.
Excellent point, yes.
Yes.
It depends.
So what about if somebody changes their appointment, for instance, a doctor says I can't do it, I'm mistaken, I have to change, does the adjuster have 21 days again?
Okay,
So it's a
so,
compelled exam that the doctor rescheduled.
right.
Or the
So-
employer, or the employer can.
Yeah, so I want to just change the way you form the question. Does the adjuster have 21 days? Think about it this way. It is the examinee that has 21 days, and it doesn't change. If it's an appointment, it's 21 days notice that they're required unless the parties agree to something else. So if you've got, again, if you've got a transfer of care, or if you've had a compelled examination, the doctor reschedules it, I don't think that in most cases you're going to have difficulty communicating with the claimant or claimant's counsel saying, you have 21 days for this, however, they can get you in X date. You will document that they're agreed to that in writing, you will send them that letter, and you will have done what you're supposed to do. Again, how do you get sued? The claimant is going to have to be aggrieved by something that you did because you said 21 days. And again, the example scenario that I gave you is the most likely way that this could happen, which is unlikely, right? You're going to set it for 10 days. You know that they have 21 days. You don't care. They didn't show up, so you're going to shut them down. That's going to get you into trouble. Rescheduling appointment, I don't see it.
The
So,
transfer of care and 10-day notice, if they don't show, suffices on our end.
say that again.
Doing a transfer of care of 10-day notice, and if they no-show, we can do the 10-day notice and suspend benefits that way.
Well, 10 and 10 is 20, not 21.
Yeah.
So again, that's my point. If you are, normally a transfer of care is not going to cause any problems whatsoever. As soon as you're saying, I'm transferring your care to Dr. Jones, and you are required to attend, that is now a compelled examination.
But I still do.
So
Right.
either way, 21 days. 20 or 21.
Or, as Carol and we have all said, talk to people. Talk to people. The law is there to set the bounds, the metes and bounds of acceptable behavior. The best way to adjust a claim is to adjust it by communicating with the folks that you need to work with to get things done, and then document it. Document it or it didn't happen. That's it.
Back to you, Miguel.
Okay, so before we move to subsection 2, there's one important thing that I glanced over in subsection 1. On the language of the provision, it says, an employee who is entitled to receive compensation. So, put it to you this way. If you are investigating a claim, the claim is closed, the claim is not, you haven't issued an acceptance, is this injured worker entitled to receive compensation so that you can send him for a 140 IME?
Yes.
You say yes.
Yes, once they file a claim, there's an entitlement to the benefit, and until it's been fully adjudicated, they're still entitled to the access of the benefits that are afforded to them in the act.
Carol says yes. I've had lawyers argue no. On a denied claim that we're holding open for medical investigation, we want to send somebody to a forced IME with a doctor of our choosing, and Miguel can speak to this, you might be one of the guys who does this. The answer is no. You don't have a claim. They're not entitled to compensation. You denied it, so no, you cannot force my client to go to an IME. If I want to request one under 145 because we have a dispute about compensability or some other issue, then I can, but you cannot.
That is precisely my point, and I think that you harped on the difference right away. If you issue a determination saying, we are not denying the claim, we're still investigating, at that point, we can argue about it. But if you're denying the claim, my position is that you are saying, and until this claim is adjudicated, and maybe it will be reversed maybe not, but until the claim is adjudicated, my position is, you are saying, and the determination that is the law right now, unless we appeal it, you are saying that my client is not entitled to receive compensation. So what I will say is, you're not entitled to request a 140 IME because this is a denied claim. Now, you do have other tools. You do have investigatory tools. Under 177, you have many other things. Nothing precludes you from scheduling a call with the injured worker in the presence of the attorney. You can definitely speak to. You have an array of tools at your disposal. But my point is the injured employee entitled to receive compensation? If it's not, what I'm saying is, I will argue that because you're stating they're not entitled to receive compensation, I will go to court and say, you can't do a 140 IME because you're saying that it's not entitled to compensation, right? A small point, but just wanted to bring it out there because we're talking about when a 140 IME applies. This is precisely when. It's for a claim. My position is for a claim that is open, right? Exactly.
Well, when you say 140, a person shouldn't, if you're going to be pursuing an IME on behalf of the employer, it should never be a formally denied claim. It should be denied pending investigation to afford you those rights to get the evaluations necessary to solidify your position. So that's that clarification I'd like to offer.
I don't disagree with that, but I have seen things.
But that's why we're here, to make sure that individuals make the appropriate decisions. Because if you deny a claim, it should be denied based on medical evidence. And if you don't have medical evidence, then it should be investigated to substantiate that position. So.
Okay.
Is the claimant entitled to an IME after that IME, if they disagree with that IME?
We're going to
Yes.
talk about 145
Yeah.
next.
We're gonna talk about that too.
Good point.
This is just the
Yeah.
employer,
Good point.
the insurer, the TPA.
Subsection 2 under 140 is quick and simple. It's a right of the insurer to request an injured employee who's receiving permanent total benefits to submit to medical examination. Here's the language of the statute. If the insurer has reasonable cause to believe that the injured employee who is receiving compensation for a permanent total disability, is no longer disabled, the insurer may request the employee to submit to an annual medical examination to determine whether the disability still exists. And the insurer shall pay for the cost of the examination. So a few wrinkles. This only applies to injured employees who are receiving permanent total. The statute is clear on what is the purpose of it, is to determine whether disability still exists. There's another one, if the insurer has reasonable cause. So what reasonable cause means is not really defined in the statute, but I would say be ready to articulate what your reasonable cause is. And that is in there, so it's not used to harass the injured worker.
Like what kind of reasonable cause?
We would, okay, what would that be like? It could be many things. You have a video of the injured employee dancing on Facebook or somewhere, and they're saying they can't do things that you're clearly seeing them say. That is probably reasonable cause, right? But it could be many things. It could be a sub rosa. It could be a medical report that you received. It could be many things. Okay, the other thing here is once a year. The statute tells you, okay, this is to be done once a year. That one is a quick and easy, but any questions on that one? Super easy. It only applies to PTD, to injured employees who are receiving permanent total benefits.
No question on that, but can we also make sure we comment on NRS 6160 for the evaluations as well? I just wanted to put that on there before I forget. So when the AO orders the IMEs for the independent examinations?
360 is,
So there's 340 and there's 360, but for our purposes, those are not, the IMEs, which is all we're talking about today, is under 140. We just read it. So it's 140 sub 1B, sub B. So ordered by an appeals officer or a hearings officer. What you're referring to under 340 and 360 is simply an examination directed by the court. It's not necessarily an independent evaluation. The court has decided, I want a doctor to weigh in on this. That's not really an IME under this context. They can do an IME under 140.
I do have a question online.
Yes.
So, 140 IME, is that something that we can do in-house, or is that something that we have to
Sorry, I even said that.
No, I think it was critical, because I think that
No, I think
sometimes
it's so
people
No, no.
get, I think adjusters sometimes get lost in what we do, and then you forget that one of the reasons we all get paid pretty well is because we are professionals.
That's why you're required to have a license now.
And we have standards and barriers, et cetera, so please go forward.
Go ahead.
Okay, so, what about staff referrals under medical necessity, where treatment is needed ASAP to ensure recovery?
It's not an
So,
item.
That's not an
a
IME.
stat,
But it's a compelled exam.
no, it isn't.
No.
A stat referral for medical treatment establishes a doctor-client patient relationship and is not a compelled examination. It's compelled by the circumstances. You got somebody who's about to die, that's an emergency, or is about to, has drop foot and is about to lose
Lose your
function.
vision.
Not a compelled examination. Again, the ways that I can give you to think about this is, A, you're making them go. B, there's no doctor-patient relationship being established. And C, if they don't go, you're going to, you potentially can shut down their claim. That's compelled examination under workers' comp. You'd have to look at it differently under district court and all of the other parts of the universe which this AB 244 applies to. For our purposes, again, probably a PPD, definitely an IME,
What about a FCE?
maybe an
Maybe.
FCE, probably an FCE, since if you're
I mean, you are
compelling them to.
compelled, right? 'Cause it's
Well,
the end of the claim.
It's usually an FCE is gonna be ordered by a doctor, it's at the end of the claim. You're not necessarily the one compelling. The doctor wants them to go so that they can figure out treatment, well, not treatment, but restrictions, et cetera, right?
If they
So,
don't go, you can.
if they don't go, you can shut down the claim. So again, there is going to be a lot of gray in here. Everybody needs to hear the words that are coming out of my mouth. This law was not written for workers' comp. We are being shoehorned into it, and we're gonna have to figure it out. There are things that I can tell you they're absolutely going to apply. IMEs, which is all we're here to talk about. Leave me alone.
Yeah.
Okay,
But
moving
I
on.
think it's good. I think
Moving on.
clarification is good, so that's good.
Okay, for those following along and still are interested to learn about the 140 IMEs, we are on subsection 3, and here's the language. I call this subsection due regard, and this is important, okay? There's going to be some, we're going to fight about this one, so get excited, okay? So here's the language. The request or order for an examination must fix a time and place with due regard for the nature of the medical examination, the convenience of the employee's physical condition, and the employee's ability to attend the place fix. What does this mean? You need to take in consideration, you need to have due regard this four elements, right? The nature of the medical examination, the convenience of the employee's physical condition, and the employee's ability to attend a time and a place fix. And this is where the communication is pivotal, because if you send a letter to us, I receive it, and I reach out, my staff reaches out, say, my client is not going to be in town on this day, or my client has presented this to the employer, and because somebody failed to send a notice to the employer, as stated in the prior provision, the employer is not giving my client this particular day. If I communicate with you, and then you go ahead and suspend benefits, my argument is going to be, are you giving my client due regard to his particular conditions? Are you giving my client due regard to the convenience, the physical condition, the nature of the medical examination, and so on and so forth? So this provision here is asking us to work together, the injured employee, us, all together. Say, let's give due regard. Let's consider the conditions on the ground with this injured worker. Are they able to go to the appointment? Okay, so, okay, no fight? I thought you were gonna say, okay.
How many times do you give due regard if your client no-shows? I mean,
Well, you always, due regard is totality of circumstances, but again, look, we don't need to make this harder than it is. Everybody that's shut off somebody's benefits because they didn't go to an IME, please raise your hands. Okay, and she's been doing this 200 million years.
Wow.
So she probably did it, how many times percentage of cases that you've handled where you shut somebody down under 140?
0.5.
0.5. This doesn't happen every day.
It doesn't.
It
We're not
should
going to
not
have this
happen.
fight, right? You're going to have, he's not going to be fighting with you when his patient, client has failed to go to the IME 2 times. He's gonna be like, I don't do what you gotta do. And then he's gonna want the judge to yell at them and explain to them why the claim was closed. And maybe the judge will reverse that, maybe they won't. In many cases, they're not going to. I'm like, I don't know what to tell you, sir. You're supposed to go to the IME, you didn't go 3 times, we're done here. Good luck to you.
Sure. Due
Right.
regard, good faith, let's all be, good faith players. If I show you a text message of my client reaching out to the employer says, no, you can't miss work. I'm like, I'm not making it up here as a message. If I show you a death certificate of my client's mother or father, I'm sure you will be okay. And I understand that there is a line and there is folks who abuse the system. And like Dalton said, I would sometimes go to court and have the judge sternly speak to my client about not missing disappointments. It doesn't happen very often too, but due regard, let's walk the line together, okay? Let's do something that makes sense. I do have some practice notes for you if you want them. So if you're going to send this notice, make sure that you send it with ample time to meet the requirements of the regulation. We've all now know that it's at least 21 days. Always send the notice to the employer as well. That will make it more likely for the employer to authorize the time off from the injured worker. Ask the injured employee to check with the doctor ahead of time, and you do a great job at that. When you send your notice, say, hey, call the doctor before. There might be some forms that might need to be filled out. That is also important to make sure that doctor is available and nothing has changed. And then I would say provide a number in case the injured employee needs to change or reschedule or reach out to counsel. Let's keep the communication open. Okay, so that is everything in subsection 3. Subsection 4 is super easy and short. The employee is entitled to to have a physician or chiropractic physician provided and paid for by the employee present at any such examination. Have you ever seen this happen? I haven't.
Never.
But it's,
I've never had it.
it's
Not
there.
yet, but it just passed in January, so,
No.
But
No,
they have to
that's
pay,
also-
they
This
have to
is
pay.
different. This
Yeah.
was already existent. This goes back to 1975. Again, 244, not workers' comp. This is work comp. So what they were saying in the bill, we already had this. This is one of the rights that they created at district court because this, again, 244, nothing to do with workers' comp. The impetus for it, all of the reasoning behind it, not workers' comp. It just happens to apply to workers' comp. But we already had a law that said that they could bring a physician, and this is it, since 1975, yes. So I just need everybody to understand, 244, we just have to comply with it because it,
so we were breaking the law when the doctors told the patient they can't bring anybody with them?
Yep.
Yes.
For, how long have I been doing this?
I don't know, but it's been on the books since 75, so however long you've been doing this, I guess.
So quick and easy one. Injured employee is entitled to have a physician, chiropractic physician, provided and paid for by the employee present at any such examination. So quick and easy one.
Again, since 1975, somebody guess how many patients have been able to afford to pay for a doctor to come to their IME with them? Okay, so
But,
let's
you know,
keep things in perspective.
I do want to insert there for a minute because,
I know.
I'm just trying to figure out whether I'm going to say names or not.
You're going to probably,
No.
you shouldn't.
There are entities in our system that have hired physicians as staff members, and those physicians are now attending those appointments. So as adjusters, you should be aware that there are certain plaintiff attorneys that have physicians on staff who will be attending those appointments.
And as adjusters, you should be aware, very, very well done, you threaded the needle. But as adjusters, you should be familiar with, he's about to get there, and we gotta have to pick up the pace, we'll never get done with this presentation. Subparagraph 6 says that any such physicians who either makes or is present at any such examination may be required to testify as to the results thereof. So as an adjuster, you probably want to be familiar with that too.
So that is subsection 6, and you just about covered it, but I want to cover subsection 5 because this is your favorite subsection. Okay? So here's the language. If the employee refuses to submit to an examination order pursuant to this statute or obstructs the examination, what happens? What is the remedy? the right of the employee to compensation is suspended until the examination takes place. And then no compensation is payable during or for the period of suspension. Aren't you excited? I mean, I thought you would be excited about that. Okay? So what does it mean?
No, now they're all worried that they're gonna get fined or sued $1,500.
So the important parts here is we need to understand what it means to refuse to submit. And like I stated before, if someone has a good faith issue that they need to address and needs to be rescheduled, that injured worker, it will be my argument in court that they have not refused. They have just trying to make it work, but they could not be present at that particular time. Okay, so what is refuse to submit and what is obstruct the examination? We need to bear in mind what those words and phrases mean, because we're gonna be in front of a judge explaining why you believe that the injured worker refused to submit to that examination, okay? So the other thing is, what is the remedy? So the remedy is, assuming you prevail, and in showing the injured employee refuses to submit, the remedy is suspension of compensation until the examination takes place. So under this provision, the remedy is not sending a notice of intention to close claim determination, is suspension of compensation. What does compensation mean? There's a definition of what compensation means, and you can suspend quite a bit of things, but this particular provision does not give you the right to close a claim, to send a letter closing the claim, not this one. Now, you would argue and you come back at me and say, well, if they miss 7, 6, 5 appointments, you better believe I'm going to send one of those. Yes, that is a different provision. That is not 140. Okay, so the remedy is suspension of compensation. So you can say, okay, so you're receiving TTD. I'm going to withhold that, okay, until you go to this appointment. That this provision also, to make it fair for you guys, ensures that you're not paying TTD or any particular benefit for an open-ended period of time. If the injured worker refuses to submit to the examination, you can you're not gonna do it for a couple of months, fair. I'm not gonna close your claim, but you're not going to receive this benefit until you go to the appointment. After that, we will reinstate it. You're not entitled to retroactive for the period of time that you missed that appointment. So does that make it fair for everybody? I think so. It makes it fair. And that tells that is actually compelling someone. The injured worker has skin in the game if they miss the appointment, okay?
So I've had lawyers for claimants argue that suspension means you can stop it, but then you have to restart it and they get the money back. The statute is clear on that point. That no compensation is payable during or for the period of suspension. So during that period of suspension, yes, it is suspended, it is denied, and then once you go, we can restart, but you're not gonna get that money.
And you gotta wait for 21 days afterwards, so that teaches you.
Exactly. So you've never had that argument from my office, right?
Correct.
Okay.
Wow.
Good job.
So we've already talked about subsection 6, so I have nothing else on 140 unless if somebody has a question. I don't know if we're going to break or I don't know how we're going to go from here. That will be up to you.
Do we wanna, we have about 10 minutes, do we wanna delve into 145 or you
No,
wanna
I think we should take
now?
a break, because 145 is gonna be even more brutal than that. So,
Well, we gotta get into-
So-
Hopefully.
and we gotta get into the doctor's stuff.
right, so let's go to, yeah,
Okay, we're gonna take a break, come
Take a
back
break,
at
come back.
10:20.
take a deep breath.
Cool.
And I
That
actually
went
think
longer
that,
than I thought.
Correct.
right, if we can find our way back to our seats so we can get started.
Okay.
The first topic was amazing. I learned so much already. I can sit here and watch that.
Teresa,
Hi.
and I know I met you years ago, and I don't know where in this session. I used to work with, I was Doc's assistant for like 12 years.
Oh, okay.
And I know that we did a whole, and I'm like, I know your face, I know your name.
Yeah,
And I'm like,
I've been hanging out. I used to be with Sedgwick and then Hartford and
yeah, maybe.
Purville and the
Because I
county.
talked to all of them, and I'm like, I mean, of course, I'm like, no, I've been like, I kind of did my own thing the last 20 years.
I knew you'd never get an IME earlier than
Consulting
20
and building.
I didn't open
Oh,
it.
so I've been doing that, but like, I'm like, now I just want to hang out with my
I'm actually going to even
Okay, hey, that's a good thing. Well, thank you so much for coming up. I appreciate you.
Like, if the agreements, I'll be like, hey, I'll see you in 10 days. And they're like, oh, I don't want to get
As long as they document it, that's fine, but they should just. That was kind of the intent of the bill.
Is there any reason why you would, on your side, say, hey, I don't want it earlier?
Only if I'm dealing with, like, let's say, for example, we have a lawyer who after somebody, they'll never get less than 21 days again, I can assure you that. Otherwise, the parties have to agree.
Gotcha. You're saying if there's no communication, you're saying
I would do it for revenge.
if what happens, what do you think the applicability law is? Usually they don't reach it. Usually they get clients. But a lot of times they'll get, I didn't hear anything about that. I didn't get anything in the mail, like, I'm not coming. But I'm like, my staff's like, not going to come and tell them. Like, first thing is tell them, tell the investors.
Okay, we're all sitting down, we're all ready to start
You
again.
communicate with the investor. We always say, hey, this is what we're doing.
Okay, hello, 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 hello. I wish I could do like Medea. Hello, hello, hello. Okay, so now we're gonna get into the real good stuff. That was fabulous. Let's go to 616C145. All right, Miguel, it's all you. Oh wait, I gotta turn to green.
And that's not making me happy.
I think all of these ones are off.
Okay.
Okay, excellent. So,
Okay, Medea.
Christie. Are all of these
Everything's on, yes, sir. I've heard the phone.
so we're going to talk about the rights of the claimant, the rights of the injured worker to request an independent medical examination. We're going to talk about a lot of that. So pay attention. This is going to be like I've heard a lot of comments about this, and I'm sure I'm going to get some at me. but
Feedback.
I'm just reading what the law says here. So okay, here we go. So follow along if you want with the text. Subsection 1. An injured employee, this is the most important section of this statute, in my opinion, except as otherwise provided in subsection 2 and 3. An injured employee may obtain an independent medical examination whenever a dispute arises from a determination issued by the insurer. Dispute, determination issued by the insurer. Those disputes need to be regarding these main three things: the approval of care, direction of treatment plan, or scope of a claim. Okay, so there's a lot in that 1A. Okay, so the injured employee is a party who may obtain the examination. Let's talk about what a dispute means. And there's no, I don't have a definition for you, but I guess we all know internally what a dispute is. But if there's, the statute seems to be saying if there's no dispute, there's no need for an IME, right? So if I were on an adjuster's shoes, I'll be like, so what are we arguing about? What is a dispute? Okay, that dispute needs to arise from a determination. So what determination you disagree with exactly that we're fighting about? Okay, and then is that determination regarding approval of care, direction of treatment plan, or scope of claim? Because if it isn't, there does not seem to, the circumstances here do not seem to give you a right to ask for a 145 IME if we're not really arguing about anything. You just want it because you want it, or why do you want it, right? So if I were, I'd just be like, okay, I just want to know, like, why are we doing it? Okay, so that's putting that out there for you guys, giving you the ammunition and come back and shoot us later. So enjoy, right? So here's subsection B. Again, an injured employee may obtain an independent medical examination within 30 days after the injured employee receives a report generated pursuant to a medical examination requested by the insurer pursuant to NRS 661.140. What does that mean? I call this the responsive IME provision. This seems to be saying whenever there is a 140 IME, whenever there's a report generated by that, whenever that report is received by the injured employee may, within 30 days of receiving that report, may request its own responsive IME on this. So what that tells me is, well, before 145, we used to, for lack of a better word, complain about how unfair the system was, because an adjuster could always ask for an IME for anything they don't like. Oh, the doctor's recommending surgery, let me get an IME. Doctor's recommending this and that. Well, I don't agree, I'm gonna get an IME. So to me, this particular provision, 1B, kind of evens out the playing field. What this tells me is if you're going to request an IME, well, I can request a responsive IME too. So what that does for me is tells me, hey, let's be careful. We both have a gun aiming at each other. How many IMEs do we want to do here?
Yeah.
Okay? So what this tells me is there is a right for the injured employee to request a responsive IME whenever you request a 140 IME. So mutually assured destruction, or?
Well, mutually assured expense, but this
Sure.
answers your question that you asked earlier, right? So we do a 140, they get a 145 in response to that. There's a couple of important points.
On a denied claim.
No, not on a denied claim.
Well, if they're-
Anytime we do a 140, they have a responsive right to a 145. Let me finish that. He read the statute to you, but it's important to note, I'll read it again. Within 30 days after an injured employee receives a report. Okay, how long does a claimant normally have to appeal a determination? 70 days, plus 3 for mailing. This is 30. They don't get to 70, 30 days. So you need to know that so that you can act accordingly, but more so it's a trap for Miguel if he's not paying attention. Now, I say it's a trap, but 145, which we'll get into, we're going to try to move quickly because we've got a whole lot to get to with doctors and Carol. But 145, as far as I'm concerned, gives the claimant infinite opportunities to appeal and get an IME. For example, the first lawyer that I caught with this at a hearing was Adam Muslusky, and Adam Muslusky sat there stunned for about 4 seconds until he realized a couple paragraphs down for him because of the circumstances and the dispute that was going on, which he did, and they granted. So, all that to say, you still need to be aware of this. But so when we talk about 145, the one thing that trips up adjusters, in my opinion, frequently is, well, they can only get one in account in a year, and then it rolls over and they can have another one. There is no limit for subparagraph 1 on how many 145 responsive IMEs that a claimant gets to everyone that you schedule. No limit whatsoever, as Miguel was suggesting. So, when this was being considered, 2017, I don't think I was doing, yeah, I was doing, it was my first legislative session on behalf of the NSIA. My argument, and the reality has been, the claimants bar believed fairness, we need this, and what I said is what you're going to see is the cost of every claim go up, and you're going to see it is not going to streamline and have claims get finished faster. What it is going to do is slow the process down, which is exactly what it has done. Every IME means there's going to be 2 or 3, and this doesn't get brought out at the beginning of the claim as frequently as it should. When it gets brought out is when we're getting ready to close the claim, things are about to wrap up, and somebody has realized, oh, there's maybe more compensation that I can get out of this if I can expand this claim. I want a 145 to make sure that I've done my job, which ends up at the time of an appeal on claim closure, extending the time that this takes. So this is one of the many reasons why, instead of having hearings that never lasted more than 2 years, hardly ever lasted more than a year, from determination to determination from the administrator, the claims adjuster, to resolution at the appeals officer, rarely ever went more than a year. This is why we have ones that sit around for 2, 3, 4 years, because it's still in litigation where another year has rolled around for another IME, and we've had that happen frequently. So it's done exactly what I said it was going to do. And again, the question is cost-benefit analysis. Is this better? I'm not so sure. I certainly understand that claimants previously, before 145 existed, wanted and needed an opportunity response when they don't have money. The overall goal is probably right. We need to have a mechanism by which a claimant can get their own medical evaluation in response to something that we're doing. But in practice, this clearly was just going to increase costs and slow things down, and it has.
I agree. We try to not be the firm who requests so many IMEs. I cannot tell you the last time that I requested a responsive IME myself. Like, that is not, but I know that it happens a lot. Just educating the public on that. One small point, Dalton said it's a trap for us. I'm going to tell you what's a trap for you. An injured employee needs to receive the report.
Right.
If you conduct the examination, doctor sends it to you, you never send it to the injured employee, the 30 days that they have to trigger their responsive IME never starts counting because they never receive a report. So make sure you send it. Make sure you send the report so the time starts counting on your behalf.
The
Okay.
second they receive the notice is when that 30 days starts?
Receive the
When they
report.
receive
They receive the medical report. So that happens quite a bit, that the injured employee doesn't receive the report, and if it.
And is that just documentation in an adjuster's computer saying I sent it out?
The
Or?
report.
No, I know, but like to just show that, like if you were to be audited,
If you were to be audited, this
you
is
just
triggered.
document?
No, it's just what the black letter law says. 30 days after the injured employee receives a report, the report.
So who gives them the report? The
As
doctor's
Miguel is
office?
saying, if we can show that the doctor handed them or gave them a report, which is generally not the way that's going to work, it's going to be the adjuster sending the claimant, along with a determination, a copy of the report. Again, to the extent that that is, the 140 has been requested presumably for some important reason to move the claim in one direction or another. So Carol, you can speak to that since you're the master adjuster. on the
Yes,
panel.
usually when an independent medical examination is scheduled on behalf of the employer, then the physician will only provide the report to the requesting party. And then it becomes the duty and responsibility of the adjuster to forward that report to the employee, as well as their representative. And the best way to make sure that that's addressed is to forward a cover letter saying, enclosed, please find a copy of the independent medical evaluation completed by Dr. Kuchera. If you have any questions or what have you, you please contact me, and then also copy their attorney as well, because then when they look at whether or not it was received, if it's a confirmed address, then usually the hearings division will recognize it being received within 3 business days following the date in which that cover letter states that it was submitted.
And on subsection, on 1C, Dalton already referred to it, but the injured employee also has a right to request an IME by asking the hearings or appeals officer for leave to conduct an IME. Okay, so that is an additional right that they have. Okay, so let's talk about subsection 2. And subsection 2 clarifies when an injured employee is entitled to an IME under subsection 1A. Okay, and the language of the subsection 2 is, an injured employee is entitled to an independent medical examination pursuant to paragraph 1 of subsection 1, paragraph A of subsection 1, only for a claim for compensation that is open. So we'll fight about what that means, but when a claim is closed, it's pretty clear that it doesn't apply, right? When the closure of a claim for compensation is under dispute pursuant to 235. So when closure, when you send one of those 10-day letters, I would argue that the 235 provision does not apply to that particular issue, but just keep an eye on that, okay? So when closure of a claim for compensation is under dispute, so there needs to be a determination, there needs to be some kind of dispute here. Or when hearing appeals is pending pursuant to 330 or 360. Someone in the room brought 330 or 360 before, so this is how they come in together. Okay, so claim that is open, closure of a claim for compensation under 235, or when there's a dispute about that closure, or when hearing or appeals officer requests that. Okay, so any questions on that before we go to subsection 3? I'm trying to leave space for Dr. Kuchera to go over things.
What is an open claim? Is it then filing a claim a claim?
No.
So-
There's,
Accepted, no? Does it have to be?
So somebody said earlier in the audience, well, when it's closed, and that is, I'll channel Bill Clinton, that depends on what his is. So, look, closed, we've had litigation around this. If you close the claim in preparation for a PPD because they've been found MMI, and you're closing it for all medical, is the claim closed?
no.
Right. So we've had folks argue that it was, and folks argue that it wasn't. It's closed when you send out that closure letter and you're not providing any benefits. But if the claim is open for ongoing medical, is it open? Is it closed?
Open.
Right. So there is room for disagreement and debate, and what lawyers do is to try and figure out how to make the law work for their circumstances and what they need to achieve. And sometimes what lawyers do is challenge the law as written because for some reason it is unfair, and they have uncovered the case that shows that this should be changed, and that's what we have a court system for. That's literally what I do all day.
One of the things that also was closed is a notice of intent to close after the 73 days expired. Because I've got nailed in court by notice of intent to close, claims closed, well, the 73 days wasn't up. They were still working on what they were doing. So it's closed is closed only if the notice is appropriate and the time is expired.
Okay, so subsection 3, Dalton already referred to it. An injured employee is entitled to only one independent medical examination per calendar year when the request is made pursuant to paragraph A of subsection 1, which is the whenever a dispute arises from the termination issued by the insurer. That one is.
And I find that some adjusters and other folks on our side get tripped up on this because they think, for example, a responsive Miguel termed it under 140, so they get a 145. Well, that's not limited to one per year. It has its own provision. Same thing when we get to subparagraph 5 for PPDs, not captured under that one per year, right? This is a claimant. The word that lawyers use, it's not exactly right, but I like it. It's sua sponte, on their own, send me for a 140. This is not about a PPD. They're saying my claim should close. That's a circumstance under which they're limited to one per calendar year.
Also, injured workers themselves now, I am beginning to see them ask for a 145 without an attorney.
And unfortunately, we have a situation where we've got hearings and appeals, well, hearings officers is mostly limited to their, in my opinion, exceeding their mandate and directing employees that they, or injured workers rather, that they
Yep.
can do a 145. It's not their role. They're there to be a umpire, call balls and strikes. Unfortunately, there's been a tendency by some to give advice about, well, you can get a 145, which shouldn't be happening.
Okay, subsection 4, here's the language. Except as otherwise provided in subsection 5, which is a subsection that talks about PPDs, and I know you want to get to that. That was in our list, so we're going to get through it. But except as provided in subsection 5, an independent medical examination must not involve treatment. It must be conducted by a physician or chiropractic physician selected by the injured employee from the panel of physician chiropractic physicians established pursuant to subsection 1 of NRS 616C090. So pretty straightforward. I know that there are questions about what constitutes treatment, and we could talk about that, and definitely Dr. Cassera and Dalton talk about that. The point I want to make here is I have requested 145 IMEs, and I requested Dr. X. The adjuster is telling me that they will not approve that doctor because I need to choose from their own PPO. That is not correct. The statute tells us who chooses the injured employee, who chooses the treating physician chiropractor, the injured employee or the representative, and where to choose from, what list to choose from. The statute is clear on that. I'm making that point so you guys put it out there for the new adjusters and everybody. We do not have to choose from your PPO. We choose from the DR list of treating doctors, okay?
Now, let me just put a finer point on this. It refers you directly to 090, subparagraph 1. 090, subparagraph 1 says, the capital A administrator shall establish a list. The capital A administrator is the administrator of the DIR. When they talk about claims adjusters and other claims administrators, they use a lowercase a. That's you. Capital A is the state. It's Tori Calderon, specifically. She shall establish a list, and that is the list that he gets to choose from, not yours. Your lowercase a.
Okay. Subsection 5, this is the subsection that allows the injured employee to request a PPD under this provision. Here's what the text says. It says, an injured employee is entitled to request an independent medical examination pursuant to paragraph A of subsection 1, so that would be once a year, pursuant to this language. It would be 1 year, for a permanent partial disability to determine what? If the injured employee has a rateable impairment, or if the injured employee is seeking to dispute an initial rating determination to obtain a second rating. So it could be that you are trying to, you send a notice of intention to close claim letter without rights to a PPD, or that they already have one that they disagree with. It could be either or, based on the language of the statute. Under this particular provision, the injured employee must select the rating physician, chiropractic physician at random from the list of qualified physician and chiropractic physicians on the DIR panel pursuant to subsection 2 of NRS 616C 490, unless, and this allows the parties to come together and agree, but unless the insurer and the injured employee otherwise agree to a rating physician or chiropractic physician. And nothing in this subsection shall be construed to prohibit an injured employee from obtaining an examination for a permanent partial disability pursuant to 100. So the injured worker may have a right under 490 to a PPD, and may have a second bite of the apple through this provision, and you'll see how it's made fair later, and you may be entitled to get reimbursed for your expenses under certain circumstances, and the injured employee also may get a third PPD under 100 in this particular instance.
So I need to make a clarification. If you're following along, anybody, looking at the Nevada legislative site, you're not going to see the language regarding subparagraph 5 that Miguel was referring Senate bill, so SB 274. 274, like 244, AB 244, is not codified. It's not in the act yet. The LCB hasn't done it. So you're going to be looking at the old language, and it doesn't have the provisions that he's going to go through today in terms of the most substantial change is that previously you could not get an IME when you were only disputing the percentage of impairment. You had to be, the dispute was regarding whether there was impairment at all. You were released MMI, no rateable impairment. Prior to last legislative session, that's a circumstance where you had to go get your own rating, and I think it referred to 616C100, which is the provision that says, go get your own rating if you dispute it. Now, the statute expressly allows, under subparagraph 5, for the claimants to get a rating, even if they only dispute the percentage of the rating. And Miguel's going to get into the other two features that include a change to what doctors can charge for it and what we can do to get some reimbursement.
Sure. Briefly, I'd like to remind everybody that this provision allows us to agree on a rating doctor. I find that agreeing on a rating doctor makes it less likely for both parties to then litigate the findings of that PPD report. So in my mind, that brings peace of mind for everybody. We can agree to doctors if you ever do. We always send a list of doctors we would agree to. I'd like to receive a list from the adjusters. If they want to send it, I'll be happy to choose from your list as well. So it just,
A PPD and an IME, is it usually together?
No.
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 And if ever we receive one, because I've received one in the past where they put in PPD and IME, they requested in there.
Who
So-
requested it?
Yeah.
The adjuster?
Plaintiff attorney.
Because there are IME doctors that are also PPD doctors, and I've noticed the trend that they tend to rate
In the
also.
IME, they wanted us to, in the IME, they wanted to include a PPD in there and have him, and unfortunately, I don't, I
So,
think
yeah,
it's just.
I understand what you're asking. I can explain. So
Closure
this,
and permanency.
but this goes away. I'm going to step on Miguel's toes and jump ahead. If you, before the law changed, the only thing that 616C145 stands for is the proposition of IMEs. We had a situation where it cost more to do an IME, or sorry, it cost more to do an IME than a PPD.
That's for real, for real.
And so nobody wanted to, under the old version of the law, send somebody for an IME, again, circumstance, claim closes, IME, no rateable impairment. The law says, send them for an IME to determine whether there should have been a PPD. Why would I spend more money on an IME to determine that and then still have to spend money on a PPD after the fact? So what we typically did prior to this year, last year when the law changed, was to simply send them for a PPD. And somebody got the wise idea to call it an IME PPD. There's no such thing, and there's no reason to create that. It only confuses the issue. My issue with this was, we had hearings officers primarily, who are not lawyers, ordering that the claimant be sent for an IME PPD. That's not a thing. Their only ability under the law was to send them to an IME to determine if there was rateable impairment. And then it would be incumbent upon my client, me, and Miguel to agree, all right, we got the order, we're not going to send them to an IME, we're just going to send them to a PPD. That's an agreement. And so that all goes away now under the law because it's unnecessary. Miguel can explain why, but that's what you're talking about. It's just nomenclature that's bad nomenclature.
subsection 6 talks about who pays for that independent medical examination. Pursuant to that section, the insurer shall pay for that cost, and upon request, should receive a copy of any report or other document that is generated as a result of that examination. Now, subsection 7, it goes to what Dalton was talking about, and he already covered some of it. But the rates of reimbursement are for when you ask for a PPD, is the rates of reimbursement for a PPD under this subsection, not an IME. And this is the language that was put in here precisely to remedy that particular issue of requesting a PPD, an IME that costs triple or 4 times the money of what a PPD costs, and then ending up at the same place of doing a PPD.
So to be clear on that, what the law changes it to is, they still only get, under the law, an IME, but he can't charge you for the regular IME rate for that IME, since it's only to determine whether a PPD should happen. He can only charge you the PPD rate.
So if you get a PPD in your IME, it's $1,000 bill, not a $20,000 bill.
So I guess for doctor's offices, if, you know, because I work with them, right? So I think when we're talking amongst ourselves, we call it an IME PPD or a PPD IME, right? Because then we know from the physician's office, okay, this is supposed to be an IME specific to the PPD. But if you just call me and say I need an IME, well, then that's different. So that's why, I think that's what you're
Okay,
saying.
but
right?
understand
The
that
PPD
if your physician gives me an IME that results in a PPD, I'm paying you $1,000, I'm not paying you the 15.
If you sent it to us
No.
to discuss rating in an IME, then that's what you'll get. But, you know what I'm saying? So if you send me just a regular IME, send me questions, send
I'm
me
not gonna
records,
send
me
you a
stuff.
PPD IME, that's what we're saying. If you, as a physician, are seeing an individual and your report ends up as a PPD, this person has a 15% impairment, I'm going to cut that bill to a PPD bill. I am not going to pay
Right.
the $15,000.
Right, that's the whole purpose of
Okay.
the patient being sent there, right? Was to discern what that PPD number was. So in our doctor's office, we call it, oh, that's an IME PPD, because then we know, right? Like, we know it's an IME, but we're gonna be talking about the PPD, and so that's why.
Let's get clear on the language,
Thank
because it's too fuzzy right now. So there's, again, after the change in the law, there are now 2 primary circumstances where you might be using 145s. One is where the old way, claim closure, no rateable impairment. We need an IME to determine whether there should have been rateable impairment. The second one now is 4%. I think it should have been a 20%. Those are different scenarios for the purposes of the doctor, because what we're generally going to do in the second case is probably just send them for a rating. We don't want an IME to determine whether the rate, because look, if you're gonna offer a 7%, the only way to offer that legally under the Nevada Industrial Insurance Act is to have a rating physician perform a rating. So adding a step of having an IME to determine, is this 3% right or should it be more, doesn't result in a report that can be used. Miguel hit on one point. We can agree to a physician, but, so paragraph 5, the parts that he read earlier that have not changed, if the IME concerns a PPD, then you have to use the rotating list for the doctor to do that, because they have to be a rating physician. Well, again, it says, I'm talking about what it said before. It now says random, but you're not gonna see that because it's not codified. So that's a whole different kettle of fish, which is not important for our purposes here. The DIR needs to give you a doctor, unless you agree with opposing counsel to a doctor to do that. And in most cases, I think today, certainly if you've got the circumstance where they're asking for 145 under the circumstance where they disagree with the percentage of impairment, which they can do now, you don't want an IME, that's a waste of money. Send them to a rater. Agree to a rater, send them to, or get somebody off the random list.
I have a question. So when you send them just for an IME to see if there is a PPD, and then the doctor says, yes, I think there's a PPD, it's 5%. As long as he was a rating physician as an adjuster, can you just offer it? Or
No,
should-
unless he did a full rating
You have to
examination.
do a full rating examination.
Right, so in order to get a PPD that you can use, that a court can order, because even the court can't order, what often will happen is, short of an IME, you might have somebody do a records review, who is a rater, and look at this and say, do you think this is right, so I can make a determination whether I should offer it. That can't be offered. The only thing that can be offered and that a judge or anybody can award, unless you're settling it, you can do whatever you want to if you're settling it. You can skip the whole process and say, I think 5%, it's that many dollars, take it, we're gonna do that on a rule out, go away. But if you're relying on a doctor to do an examination and determine a level of impairment, that has to be done either pursuant to written agreement of the parties, which still has to go to the DIR for a D35. To short circuit all of this, you're gonna offer that rating through the court system or through the normal course, there must be a D35. And even if we agree, the process now is we have to complete a D35 saying that we agree to Dr. Joe Blow.
Okay, subsection 8 states that if the injured employee requests an independent medical examination pursuant to subsection 5, so for a PPD, and the second rating does not result in a higher percentage of disability than the initial rating, then the insurer may recover the cost of the independent medical examination determined in accordance to the rates of reimbursement specified. So basically, you're gonna get the PPD money. And this is new, this is part of the new language, so on this one, we may wanna drill down a little bit. What happens if there's a zero?
Right.
What happens?
So this language was added because I pushed for it when they changed the law, so I got, this gives us the
Congratulations,
ability.
you're such a powerful.
Yeah, no, we have virtually no power. They literally have a supermajority in one house and a near supermajority in the other, and they may end up with supermajorities in both. We're just fighting over crumbs and just trying to, beg, hey, can you please not screw us the hardest that you possibly could? In this case, though, what we have is, as Miguel said, if the claimant has the temerity to go and ask for 145 to increase the percentage of their impairment, they better do so, because if they don't, while we have to pay for the IME slash PPD,
Yeah.
or, I'm gonna say or, we have to pay for it up front. If they don't improve, if they get a 5 and it comes back as a 5 or a 0, then they have to reimburse us for the cost of that examination. However, there are several caveats. The only source of money for that reimbursement is the PPD that it's at issue. So you don't get an offset, you can't take it out of all of their benefits, and as Miguel said, if we started a 0, they use 145 and get a 0, 0 minus 275 or 1,000 or whatever number you want to put is still 0, so you're not getting your money back, right? But in the case that there is an award that's at issue, you will get reimbursed for the cost of the second evaluation.
You should be happy about this particular provision because it puts skin in the game for the injured employee. They're not going to, I don't know if you ever do, but I do get clients that sometimes do not take my advice. I have a PPD, I tell them, okay, I've done this, I've seen about 1,000 PPDs. This is fair under the circumstances. They're like, no, it's not enough. I want more money. I'm like, well, you have this right, but if you do end up getting the same or less, then it comes out of your pocket. And you usually think about it and they're like, so you've done about 1,000. You think this is correct? I'm like, yeah, it looks good. So they end up taking it. So this makes your life easy and it makes it fair. Okay, so that is, I don't think that was a small thing, Dalton. I think that was pretty good. Subsection 9 talks about what these provisions do not apply when you request when an IME is ordered by the hearing or appeals officer. So that doesn't really apply a whole lot to the adjuster's practice.
Can I ask, we talked about the process of bringing somebody in for an IME and communicating with the client. Doctor, do you send the reports to claimants ever? Can you talk about that process?
So no, we always send it to, we have them sign a records release, and we always send it to the adjuster. Sometimes we are requested by counsel, and counsel to provide it, and I've never charged or I just provide it. Claimant, we tell the claimant, you need to contact your adjuster. If the adjuster says you can go ahead and give it to him, I will do that. It's like Dalton says, it's all about communication.
I think we're probably done with 145.
Yes, we are.
We can maybe ask if there's any questions on that, and then let's get into the.
No, it's too painful. It's too painful. No, I think let's move on to why. Let's move on and start with, actually, I'd like to start with the doctor and talk about, what is an IME? Because you won my heart yesterday when you quoted the AMA, because I feel that way, but the world doesn't. So if you would, sir.
Sure. IMEs, we call it independent medical examination or independent medical evaluation in the state of Nevada. Some states call it a CME, some states call it, there's a bunch of different terms. QME, like QME. And basically, there's a medical issue arise, and you're being asked, whether by the court, by the insurance company, to provide a medical legal opinion based on your judgment to a reasonable degree of medical probability. Everyone loves, that's what we have in the state of Nevada, which is more likely than not 51% or greater. The most important thing from the doctor perspective that's, I think, been touched upon is you shouldn't be a treating physician, definitely not prior, post, we can talk about that. And the reason is IMEs, like Mr. Hooks here brought up, don't establish a doctor-patient relationship. When you establish a doctor-patient relationship with a claimant patient, you have to, by medical code of ethics, by the AMA, you have to act in their best interest, right? You have a duty to them, not to the insurer, not to anyone, you have a duty to them. And you could be held in malpractice if you don't do that duty. When you're an IME examiner, and I hope they're all IME examiners, the first thing you sit down, you tell them the rules. This is ordered by so-and-so. These are the questions that I'm being asked. You and I do not have a doctor-patient relationship. You will not see me after this. I will put in my report everything you say. I will provide it to the insurance company. It's not an order of action. They don't have to do anything I say. I'm giving an opinion. I tell every person that comes through my doors that this is not a doctor. Whatever I say in here doesn't need to be done. It's an opinion based on my medical judgment and experience treating similar injuries. So that's the clarification. Should not be a treating physician. That's well established in the AMA. It's kind of stated in the law, kind of vaguely, but the AMA specifically says you shouldn't be a past, present, or future. Okay. I'll touch the future right now.
Okay, I'm gonna hold on one sec. So 145 is not a second way to get a TOC. A 145, I get a 145, I get an IME from Dr. So-and-so, spine surgeon. I'm not going to accept the letter from the attorney saying, now I want him to go to that IME doctor, and that IME doctor is the treating now physician. No.
No. Okay.
That's right, man.
That's a very good point. I would like to, so the AMA does say it should not be the IME treating physician, and I strongly encourage most physicians to not do that, because then you're now establishing, if there's follow-up questions from the insurer, from counsel, you can't provide those, right? Because you've now established that relationship. So IME, sometimes you get records later, ask for an addendum report, which is allowed as well. You should not be providing that as a treating physician because now you've established a doctor. There is one
Yeah, Dr. Kios has a question.
I have a question.
Yeah.
How do you handle someone with a medical emergency walking to your IME?
So good question. Medical emergency, that is your limited doctor-patient relationship. If they're coming in with a suspected stroke, which is a recent thing for me, you have to send them to the hospital. You have a duty. The duty from the AMA states if you find something that has been not yet identified, and you do not tell that patient, whether it's call an ambulance for them, tell them you should seek this, even if it's like this skin mold doesn't look, you need to see a dermatologist. You need to document it. You need to document that. Or you reviewed their MRI, and their MRI said they had, you look at their spine MRI, and they have, ovarian cyst. Hey, did your doctor tell you that, right? No one's told me that. You have a legal obligation to say you need follow-up from that. The radiologist says right here you should follow up. And so if you discover something that has not been discovered or treated, you do have a duty to tell them. And that's the one place where you could get dinged for malpractice.
You've got a Hippocratic oath, but also the reason that you don't want to be the treating physician and doing an IME is from a legal standpoint, we're concerned about bias, right? You could have been 2 doctors ago, but you're still looking at somebody who might have a condition that is subject to advice, procedure, something that you did that now you have your own interests tied up in the interests of that patient. So from a legal standpoint, that's why we want it to be clean. We want it to truly be independent.
The one caveat I would say in the state of Nevada that the AMA, AMA is written a lot by East Coast physicians where they have lots of physicians. We are 50th per capita in physicians, not necessarily in pain or spine surgeons, but as I'm speaking to the choir here, neurology, ENT, things of that sort. So or neuro-ophthalmology, I saw an IME. So if you have, say, an IME for some neuro-ophthalmological, these are rare, they don't happen, but good luck finding another physician. We only have a couple of them. Good luck finding a neurologist. So in my opinion, and I know Mr. Oaks would agree, in those specific circumstances, when there's no one else to provide that care, I think it's reasonable after the IME, if it's something that that person can provide, that's not an unreasonable pursuit. But in general, if there's someone else to provide the care, it should not
Yeah, and it's in terms of the scenario that you brought up, and I'd like to hear Miguel's opinion. I think that what you want to do in that circumstance is recognize that you might have to go outside of the state for the IME, right? Because we do want, I, I am very reticent to have out-of-state doctors treating on Nevada workers' compensation claims because they don't understand the law. They don't know, it just makes things harder. And from a selfish standpoint for claims adjusters and insurance companies, once you open that door to somebody treating outside of the state, it's nearly impossible to close it. And that's lifetime of the case. And I've had several cases that were long in the tooth that I had to deal with doctors in California who, we couldn't, at the time, we didn't have a specialty here, so we let the claimant treat in California. That doctor is the only person that the claimant is willing to treat with because they view them as an expert, they know the history, blah, 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 but now they don't want to do fee schedule anymore, right? Or they're getting ready to retire. So I would flop that. If you're going to do an IME, and you know it's one of the areas where we don't have more than one physician here, do the IME with somebody else out of state.
And I suggest you look towards Arizona, not California. Arizona has a phenomenal medical base. California has a unique personality.
Good way to put it. That's one way to put it. Good way to put it. Very, you're really PC today.
I'm trying really hard. I'm trying really hard not to be out of line.
And so the issues, the most common ones at least come across my desk. The PPD rating we were talking about, I'm not beating a dead horse, that's come across once or twice. I'm not a PPD rating exam, so like Mr. Hook said, that I even myself say that's a really expensive proposition. You're coming to me to say, yep, based on the fifth guides, you do meet the rateable impairment. I did not perform a full rating exam, range of motion, I didn't bring out the goniometer, and so then they have to go to a PPD anyways. So I've seen those rarely because usually that's expensive. I'm saying go to a rating exam or go there first probably. Most common scope of claim, further treatment, right? Scope of claim being common either at the beginning of the claim or at the end of the claim, like Counselor said. And those are the most common ones that I see. From the doctor perspective, I'll give you a couple points. We've talked a lot today, I think everything's about communications. 80% of the time when I walk into that room, they're not happy to see me. They're not, because most of the time people haven't explained to them, right? They just have not, they've had a bad IME experience before with a doctor who walked in, touched them and left, didn't explain to them. I usually start with the same bad joke saying, hey, you're probably not happy to see me. No one ever comes to say hi to me, like, hi, here's my name, and explain to them the process. Most, some adjusters are great, attorneys are great, but a lot of times they don't know why they're there. So I have to explain to them the entire process, no doctor-patient relationship, things we talked about. I look at the records afterwards. For the records are the most important thing for the adjusters. Most adjusters, attorneys' offices, Mr. Hook's office is great about sending it in Bates stamped, which is also fun to go through, you want all the records, and specifically, I'd say the thing that as a physician is most frustrating is the pre-existing records. Sometimes they get sent. Believe it or not, most injured workers are pretty truthful, right? More often than not, 90% of the time. They'll tell you, I had a previous rating, I had a previous knee injury, same job, been working at the casino for 25 years. And I never, rarely do I get someone, I'm not saying you have to send me all the records, do I get that rating examination? Most rating examinations in the state of Nevada are very well written. It really, especially if it's the same body part, it really helps. Because patients are not the greatest historians. They're saying, I injured, who'd you go treat with? Oh, those are Jones and Hualapai. I mean, they know the location, but they don't know the doctor's name if they've been operated on. So the previous ratings, I understand it gets expensive when you start adding records, but that really helps establish that pre-existing. They will usually tell you if they've been seeing a pain management doc, usually, and getting injections beforehand. Was it 3 months ago? Was it 3 years ago? Are you still treating? Are you on opioids? Opioids I can see by looking up on Nevada PMP. But, I would say more often than not, I don't get the pre-existing records. So you're trying to put together, was this a substantially worsened precipitating cause? And then a lot of our guest room attendants, they have multiple shoulder injuries, multiple knee injuries, right? And so it really would help to see those previous ratings, because usually the rating examiner is putting their range of motion in there and putting their MRI, so you can objectively say, did this really get that much worse with this? Is this a temporary exacerbation, or is this actually aggravation? So records are the most important thing. most of the time I get all of them, C4, consensual records, because when you're establishing causation, okay, there's two ways to look at it. Does the medical evidence support this kind of mechanism injury can cause that? That's number one. And then temporal causation, the MA says that. So is it reasonable that this symptom developed in XYZ time, right? So if you see though, and concentra's, we're not going to, go back and forth about things, but usually, and nurse practitioners are very good about putting all the documented complaints in the HPI, because the nurse does that and then the doctor puts in their diagnosis. They may be thorough with it. They may, C4s are sometimes super helpful and sometimes they're blank, right? So you're doing this investigative journalism, trying to figure out, like, does everything kind of match? And like Mr. Oak said, like, some of these claims are now 4 years out, right? So you're asking someone 4 years ago, what hurt in that first week? Like, did you tell anyone?
Right.
And they're like, good luck. I don't remember what hurt 4 years ago. So those initial records are super important to establish, did they temporarily complain of this? And most patients will tell you, yeah, my back started hurting. When it started hurting? 4 or 5 months ago. So it's 6 months after the claim. Well, that's not going to be industrial, right? Like, you may think it is, but it's not going to be industrial. So those records are the most important thing, because there's subjective findings or complaints from the patient, and there's objective, right? Any specific questions before I rant on?
I just want to key in off of what you said with regard to our office sending you base stamped documents, and there's a reason for that. So let's say Miguel's on the other side of the case, you give an opinion, he really doesn't like it. What he's going to be looking to do is to call into question your opinion, right? So in order to do that, the first question he's going to ask, well, did you have all the records? And what we try to do is head off at the path these discussions, because if we don't know what we sent you, we can't say to you, and let's say Miguel raises this question, what we can do before we get into court is confirm with you, doctor, can you please tell us what records we had, you received from our office. We sent you your base stamp pages 1 through 175, and pages 20 to 35 were the 1990 PPD examination. Did you see and review that? And right, and so when you respond to that, if we can do it in that manner, saves on litigation. It helps, and so that's one of the reasons we do this. You raised a lot of issues that I think we kind of want to jump back to a little bit. One is you talked about aggravation, acceleration, which of course gets into 175, but one of the things that we had on here that we wanted to talk about is cumulative trauma, and I think we should probably get into that as part of this discussion and then do some of the other stuff. So I don't know, Carol, if you want to talk about cumulative trauma in terms of where that comes up in your work.
Well, specifically, the Act does not recognize cumulative trauma as a mechanism of injury for the state of Nevada. We have very specific, guidelines with regards to accidents and injuries. So individuals that allege that they have developed problems because they've developed over time kind of makes it very precarious when we're addressing compensability under 150, as well as when we're addressing issues when it goes to the docs that are looking at it, because the statute is very, very specific. The only times that you recognize situations where you're talking about cumulative trauma is where you're looking under occupational diseases, and then it's very, very specific in that regard as well. So those are things that you want to make sure that you vet out when you're reviewing your claims, as far as the accident details and what information they're providing as to what the cause is, because in Nevada there specifically has to be an unexpected or unforeseen event that occurred from a traumatic event that caused an injury that's confirmed by objective medical evidence. And so, those are the things that you want to keep in mind when you start to see those claims being presented to you. Is that along the lines?
Yeah, exactly. I mean, in the Golden State and many other states you can have, I've been working at the same job for 40 years, and in that job I have to climb a lot of stairs, and so my knees are bad now. That can be a claim. In Nevada, you have to have, as Carol said, she almost gave you the statute word for word from the top of her head, which is you have to have a discrete event that at the time causes immediate, so you cannot be injured in the state of Nevada and not know it.
Right.
have to know because it's literally one of the requirements. There has to be an immediate reaction. You have to feel pain or some other indicia of an injury. Pain is not enough. So as she said, you then have to have that established by objective medical evidence. So objective medical evidence, doctors, what kind of things are we looking for? Is one of them muscle spasm? If so, why?
Yeah, so muscle spasm is actually, a ratable impairment too, if you look at the diagnosis-related groups in the PPD. Objective can be defined in physical examination findings, decreased range of motion, right? These are things that are also in PPD. Muscle spasms, radiculopathies. I don't want to get into radiculopathies, but EMGs are helpful, but they do not exclude, right? 50% of the times you have a normal EMG, you can still have radiculopathy. So it helps confirm, right? It's like the preponderance of evidence, right? So does MRI findings, X-ray fractures are easy. X-ray, broken bone, right? The soft tissue stuff is more difficult. Your sprain strains, right? Your contusions, because by the time they come to me, they generally don't have that contusion on them. I don't generally see them that early on. So is that contusion resolved? Is there something more? Is there meniscus? Is there labrum? So is there objective being MRI findings, physical examination findings that have known tested specificity and sensitivities, which I don't really get crazy into, right? But there's certain physical exam findings that are more specifically objective. They've been tested in the literature, like Sperling signs for cervical radiculopathy, straight legs. Those are pretty well established that they are very specific for a certain injury. MRI, and obviously the ER docs or the occupational docs in the first couple of weeks, contusions, lacerations, things of that sort.
One of the things that we were supposed to talk about, Carol, also was in terms of when you're using an IME, when are you using an IME versus a second opinion in your work and your practice?
Well, I like to use the coin of phrase, whether or not you're looking for a resolution or whether or not you're looking for confirmation. And when we talk about resolution, we're talking about dispute resolution. So if there's a dispute, then that's an indication for an independent medical evaluation. There's opposing opinions about what's going on, and you're trying to get some resolution regarding that dispute. And I think oftentimes IMEs are used inappropriately because second opinion would be better suited. So then that's when you're talking about a second opinion is when you're looking for confirmation. So I kind of jotted down some notes with regards to those. But second opinions, you want to confirm a diagnosis or a treatment plan. So there's no issue of dispute that the person has a problem. It's just trying to confirm what the nature of that problem is or what the appropriate course of treatment is versus whether or not the problem occurred to begin with. Then you want to look at whether or not it's going to provide some insight if there's some lack of improvement. So say you have accepted condition, the individual is treating, but for whatever reason, they're not progressing towards recovery. Well, then you're looking toward a second opinion to see, can I identify an alternative treatment option, or is there something that may have been overlooked? And so that's when you can engage with the claimant attorney if there's issues or concerns, or even with the treating physician and said, hey, I'm recognizing that this claim is not moving or progressing, or the path is not moving towards resolution. Do you think a second opinion from maybe a different specialty or whatever the case may be? But these are collaborative, communicative efforts to try to move the claim forward. Other times is if you have invasive or high-risk procedures, or even in some instances, things that are not FDA approved that are still in their trial stages, then you may want to get a second opinion to try to confirm whether or not there's familiarity with what those recommendations are, or agreement because you want to make sure that the best course of treatment is being pursued. So lots of times when these situations present themselves, individuals automatically want to go to the IME route. The IME route really should be catered towards resolving a dispute, not trying to confirm what the best course of action is. Some other instances, sometimes you run into situations where the treating physician will ask for a second opinion. And I would always say, if a treating physician is partnering with you and trying to get you to engage another doctor to help them to make sure that the best care is being provided to that injured employee, that you want to take advantage of that. Denying a second opinion that's being requested by a treating physician kind of puts you at a disadvantage because they're opening up their opportunities to welcome another professional into that realm of that treatment so that they could get the best resolve. And if you don't go that direction, then I bet you the next thing you're going to get is a request for an IME. So just to reiterate, there's a great opportunity to utilize second opinions to support you to medically address the handling of your claims, and don't always jump to the IME route, because the IME is truly should be directed towards dispute resolution.
Carol, though, there is going to be a countervailing view that I'm sure, I had a hand go up, and it might be the question that I'm going to ask you, which is, well, what about the idea that I don't want to do a second opinion? I'd rather have Miguel earn one of his 145s, because if I do a second opinion and it's a dispute about scope of claim, maybe he'll just do a 145 after, and now I've got to do it again.
Well, scope of claim, if there's a dispute, that's IME.
Right.
Because remember, the way that I encourage, adjusters to look at it is, if there's a dispute, then you might have to go the IME route. But if there's clarification, then those are things that you can work with collaboratively to try to
What if a
address it.
dispute arises out of your clarification? For example, it's treatment plan, which is one of the things that he can get a 145 for, and your second opinion and your doctor both agree on the strategy, and the claimant doesn't, and then requests a 145. Or what if there's a split between the two, and you want to go on one direction and Miguel doesn't? And I'd love to hear from Miguel on this in terms of how it plays out for him. I know what I see. That, well, I'm not going to do that under a second opinion. That's just going to set him up. I got to pay for the second opinion, and then he's going to ask for 145, and then he hasn't burned his 145 for the year. So, thoughts on that?
Sometimes those situations present themselves, and unfortunately, that's just the route that you have to take. I just encourage individuals to try to utilize and recognize that second opinions can be a very valuable tool, but you'll run into situations where injured employees are obstinate, claimant attorneys are obstinate, defense attorneys are obstinate. It's just, but if there is those efforts that are employed, you will recognize that there's an opportunity for the claim to move better. Because if individuals are engaging and talking about things, like to say, I don't want to give a second opinion because I'm not going to give a 145, kind of implies to me that there was really no true interest in identifying how the claim's going to move forward. It's identifying whether or not you're going to win.
Yeah, so with that being said, I really encourage physicians and their schedulers to also understand, if we're requesting a second opinion, maybe clarify with the carrier, because the carrier is being pushed to do an IME instead of a second opinion based on the age of the claim or whatever it may be, that the doctor doesn't want to do a second opinion, wants an IME, so they charge us more for it too. So clarify with the carrier why they want the second opinion before you say, nope, he'll only do it as an IME.
I also
That was also a question on here with multiple likes, so clearly that is a problem when they
Huge
request a
problem.
second opinion and they won't do it because they want an IME. So,
Well, my suggestion would be when you're talking to that scheduler, you might communicate with your physician. Second opinion means you might get the business, and IME means that you get this one baby.
hopefully but also you have to understand, you have to understand that.
So, yeah.
And sometimes we get second opinions that are 300, 500 pages.
Can't you
And
bill
so-
for an addition, can't you bill for the,
So yes, you can do the record review, right? You
Right.
can bill it at $486 per 100 pages,
Right.
which is what they do. So if that's the case, then yes, the doctor can get some money for the compensation for going through all those records. But at the end of the day, you're gonna get paid $250 for a second opinion, right? That's like the second opinion charge.
Yeah, but I think Ann's
Give or
point
take.
should not be ignored. What
yeah,
she's
but
saying is-
that, if you tell me that you can't do a second opinion and it's an IME, if I don't hang up on you, I'm going to then go, okay, and you won't get
Either.
that patient. You
But if
won't
you
get
get
that
him as an
patient.
IME, you can't treat.
If you
right?
get,
So-
if you take that $5,000 up front or the $15,000 up front, then you don't get the patient. If you do a second opinion, you get the patient.
And maybe that surgery case too.
Right, and that's really where we do a lot of the seconds, is with the surgeries and
But
stuff.
then you also have to understand that adjusters will send us letters with questions for a second opinion as if it's an IME. So then the doctor's like, wait a second, what am I doing? Is
Can't
this
you
an
bill
IME
for it,
or is
can't
this
you
a
bill
second
for that too?
opinion? A second opinion to a physician is, does the patient need surgery, yes or no? Does the patient need a total knee replacement, yes or no? Does the patient have, so it's not necessarily, does the patient need a total replacement? And if not, what is the recommendation? Because that's an IME. That's not really a
And keep in mind, second opinions, the adjuster can engage with the physician. IMEs, they cannot.
Right.
So if you're engaging with the physician, then you can identify collaboratively what is it that you're looking for. You know, this doctor's recommending this. The employee has concerns. Most of the times, and in my experience, my second opinion doctors end up being the treaters.
Yep.
Because once they go there, they get that comfort, they get that understanding, they get another approach. Then they say, hey, you know, I really like them. Can I, you know, transfer my care? Which, like, you know, Ann had said, you know, second opinion, you can treat. IME, you are done. So then, you know, you can engage, but an IME, because it is an independent medical evaluation, you have to draft what those communications are or what that issue is, and you have to get the other parties involved and make them fully aware of it, and that's it. That's the only thing that they can address. But you're establishing a patient relationship to try to confirm that the treatment that they're giving or the course of action that's going to be taken is going to be in their best interest.
It's important for you guys as administrators and adjusters to understand this conversation, because it's one of the things that triggers me. I love that word. It's one of the things that triggers me with regard to that is I get, certainly no disrespect, I get a plaintiff attorney saying, I want Dr. Cut everything and for an IME. And so I go, okay, I said the IME with Dr. Cut everything. Dr. Cut everything comes back and says, I need to cut everything. And they say, okay, I want to transfer to Dr. Cut everything. No, I say no, and I'm litigating those continuously now because the answer is no. And you've burned it. So now let's go to a doctor that does medicine and doesn't cut everything, and here we've got treatment plan progression. Okay,
But
that was it.
like we talked about the communication again. So
Yes.
when I get a second opinion request, I always have my office ask, hey, what is the issue? What do you
Yes.
want answered from me? How many pages is it going to be? If it's, hey, so-and-so from me, pain management, usually spinal cord stimulation, right? So they recommend a spinal cord stimulator. Do you agree? Okay, that's a reasonable second opinion. We're going to get them in sooner than 21 days. I'm going to give you an opinion. Does this person's condition, diagnosis warrant that kind of invasive intervention? I will, during that second opinion, tell them all the good things and the bad things about a spinal cord stimulator, right? All of them, so that they can have an informed decision, and then they go back. If adjuster reaches out to my office and says, hey, we want a scope of claim, further treatment, can you opine on the pre-existing? Well, now you're starting to get into a lot of things. I'm going to suggest, I'm never going to force them, as hey, that many records, 800 records, that's going to be an IME. You're going to want a good opinion. You know, I'm not going to write my 35 to 46-page IME on a second opinion like that. But like Carol says, if we're just confirming treatment, this person recommended surgery, injection, spinal cord stimulator, is this a good idea? And because you can establish a doctor-patient relationship, you can then counsel them. I'm not supposed to counsel during an IME. I'm not supposed to provide any treatment advice of any kind unless they come to me with some sort of medical condition like stroke. None. And they ask me all the time, and I'm like, I'm sorry, I can't give you medical advice. Right? I'm not a treating physician.
So what happens when you have a patient that comes in for an IME and then they need an MRI? You order that? And then
So if I think they need an MRI, that's actually a tricky thing, because when you order an MRI in the state of Nevada or any state and something adverse happens, it's not common, but in my 8 years in Vegas, I've diagnosed cancer 3 times on a work comp. So if you order that and you don't get them back, and God forbid you would find a kidney cancer, which is my last one, an officer, then you're definitely liable. So I told the adjuster I'd prefer it to come from the treating physician if they still have one. I would prefer that because they have an established relationship. If there is nobody, I will do it if I think it's reasonable and necessary as it relates to that. But I make the adjuster allow me to do a one-time follow-up to discuss that MRI, just because that happens, right? It's rare, but I would be absolutely devastated if you missed the cancer because, you know, you didn't review that MRI afterwards.
And you just tell the adjuster you need a follow-up, so you can add an addendum to
And
your
the addendum as well,
Mhm.
yeah. But I usually
Do
think,
adjusters agree on the second follow-up?
if there's no established treating physician, most of the time they will.
And if it's to get the finalized report with an addendum,
Yeah.
you'd be a fool not to.
So otherwise, the treating physician would order it, treating physician would follow up, and then send you a report.
If he agreed, right?
And then
These
you
are
would do an addendum.
these are opinions. You know, usually when they come for scope of claims, they've had some sort of workup, right? That recommendation maybe say, hey, see an orthopedist on a rule-out basis, right? I'm not going to, you know, because they're still going to need that orthopedic opinion. Does that person need any care? You know, does that person need care for that sprain strain, or is it like, hey, you're done, right? So, like for spine, they usually come to me already with an MRI, right? And like I said, I'm not a try to practice cost-effective medicine.
Did you hear that, everyone?
When addressing this issue or any issue, I am reminded to go back to the guiding principles of the legislature when they put together the Nevada Industrial Insurance Act. And I want to read it to you because it is my North Star. And everything I do, I approach being mindful of this particular provision. NRS 616C A010. This is the legislature's mandate for us when we're fighting. This is what they're telling us. The provisions of chapters of NRS 616CA through 617, so the whole of the chapter, the whole of the act, must be interpreted and construed to ensure the quick and efficient payment of compensation to employees who are injured or disabled to a reasonable cost to employers who are subject to the provisions of these chapters. So what the legislature is saying is, let's get together. Let's do this together. Everything we do, it should be channeled into trying to find a common ground to provide benefit to the injured worker in a way that is cost efficient to the employer. That's how we all come together. That's how we all survive. It starts with a phone call. Let's call us. Is a second opinion the right way to go? Is it an IME? If there's an IME, will there be a responsive one? Are we going to set the claim back a year? Do you think I want to sit on claim for a year? Neither do you. We don't want to do this. So let's talk about it. Let's see how we can come up together. This is the legislature telling us, let's come together. This is a mandate. This is what you guys on both sides of the aisle are supposed to do. Let's try to do this together in a way that pays benefit to the injured employee in a way that doesn't bankrupt the employers. Let's do it together. So that is my approach to this particular issue and any other issue that I sit in front of when I try to do it. Hopefully that means something to you guys.
Let's add comorbidities. Let's deal with comorbidities when you have them in a claim. And actually, if we could, Carol, if you could give a little bit and then we'll bounce to the doctor on that.
Well, usually, unfortunately, we kind of hire people as is. So sometimes people are predisposed, whether it be to genetics, whether it be to prior injuries, whether it be to prior surgeries, or whatever the case may be. And sometimes those conditions or those problems kind of spill over into your work injury. And so there's a difficult time in kind of separating. Is this due to the injury, or was this due to the natural progression of whatever that pre-existing condition was, or what have you? And lots of times we as adjusters want to make decisions on that when the decision rests with the medical provider. So that's another situation where you run into wanting to utilize an independent medical evaluation so that you can get clarity on that, because they can, based on their evaluation, their familiarity with regards to treatment, symptomology, so on and so forth, can determine whether or not, their current problems or a natural progression of their pre-existing condition, or an exacerbation, or an acceleration, or what have you. So when we're talking about comorbidities, you really want to engage a physician in that determination.
On that real quick, sometimes it's avoidable too, or all we really need is by 51% or more, the correlation, and unfortunately it's going to be yours. So if you can just add that language to our questions to either the primary physician or the independent, it's pretty solid.
I was going to stay silent on this, but now it's happened twice, so I have to speak. Some of you already know what I'm going to say.
Preponderance.
A preponderance of the evidence is not 51%. It is 50.00000001. It is more than even. 51% is a rule of thumb that people use. I've heard judges say it, which absolutely terrifies me when a judge says 51%. You're really supposed to know. You went to law school and you literally do this. It is more than the other side. So the smallest number that you can think of, again, think of this as, and it's important, and I'll explain why it's important. Yeah, literally out to infinity, but the way the Supreme Court once described it, that is a good visual, it's like a gossamer wing on a scale. It's nothing. It's just more than even. And so that has two relevant principles. One, generally speaking, everything that we talked about is the claimant's burden to carry that, right? But when we're talking about comorbidities, pre-existing conditions, it switches under NRS 616C175 to us, right? So now I've got the burden of establishing that the claimant are the basis for his or her impairment under the act and inability to go back to their pre-injury employment. And I've got to show that, and the burden is the same for me. A preponderance, you've got clear and convincing, which is a standard that's in between beyond reasonable doubt, which is the criminal standard. Your life and liberty are on the line. It has to be absolutely clear. So they don't quantify that, but you got to get 12 people to agree that you really messed up, right? Then a clear and convincing standard, which appears in the act under certain circumstances, like you want to reopen your claim within a year of it closing, or you want to demonstrate that you've got a mental impairment under 180. It's a clear and convincing standard. And then we come to the lowest one, which is preponderance. So everybody needs to understand that's a very small. So you can get to that if you think about the Milko case, which talks about an injury. The claimant was reaching for a file. She didn't touch a file. She was reaching for a file. She felt pain in her shoulder. There was objective indicia of that because she did have spasms when she went to the doctor. We talked about that early. Spasms are objective because pain is subjective. You cannot have a claim in Nevada for pain. Spasms are not within your control. If your muscles are spasming, Doctor, you've everybody fake a spasm for you that you couldn't tell it was.
They couldn't tell, no.
Right.
They, you can tell, yes.
I'm sure you've had people, yeah, right, because it's not within your regular normal. It's autonomic, right?
Yeah. So usually you say, the subjective complaints outweigh the objective evidence.
There you go. And you used to just say that was malingering, but now you're like.
I got to be a little more PC. I just say that.
So that burden is super low. But anyways, Milko, she's reaching for a file, she never touches it, and that is enough because she had pain and objective symptoms of injury to establish an injury arising out of her employment. As I said before, you can't have an injury and not know it. If she reached for the file and some days later said, I don't know what happened, but my job involves moving files around all the time. Sorry, denied. You're not in the golden state. Objective, immediate symptoms of an injury. And the proof is just more than the other side. What did she have? She had the doctor. In that particular case, the lady she worked for an attorney who has now been disbarred. He decided, as a guy who doesn't do workers' comp, that he would take this all the way up to the Supreme Court because he knew better than anybody else. Got his butt handed to him. Eventually lost his license. But the evidence, she also didn't report it until after she was fired, allegedly. Well, the court said, in that case, two things that are important. One, the description of an injury that I just gave you, which is next to nothing. So when you're thinking about somebody that you've got a case where, they only lifted a box of tissue, I don't know why this claim should be compensable. Follow your facts, deny it if you think you must, but not ever touching anything and reaching for it is still enough. So your box of Kleenex is not as absurd as you think, at least according to the Nevada Supreme Court. We might have a different discussion over beers. But the law is what it is, right? So the compensability is determined by those factors. She had more evidence under the standard for preponderance of the evidence because she was able to demonstrate, well, I didn't get injured in between the time that you fired me to when I went to the doctor. So that rebuts the presumption that if somebody reports it after employment, it's deemed, generally speaking, not to rise out of employment. But it also shows how little evidence there is to tip that scale, right? So you just want to be careful and aware of that.
Any questions, any concerns?
Anything online?
It's a lot of information. Yes, sir.
What qualifies a doctor to perform IMEs?
It's a very good question. We were just talking about that earlier. So in the state, the AMA says it should be within your specialty. You should be board certified. You should have a license to practice in the state that you're doing IME. There is formal training available, but in the state of Nevada, it's not required. In certain states, you actually have to file an application, do at least a basic law test, which I actually think wouldn't be a bad idea in the state of Nevada. So some states make you do that. In the state of Nevada, you just have to be on the DIR panel. You have to be an active practicing physician. It should be within your scope. That's really honestly it.
The key legal distinction is, as we talked about earlier, you have to be on the big A administrators list, which is what the doctor was just referring to. different if you're doing a PPD under subsection 5 of 145, or excuse me, an IME under subsection 5, which concerns a PPD. Then you have to have the qualifications to be a rater, and you have to be selected off of the list either by the parties agreeing or by random selection under the new changes to the law.
So what gets you on that list?
Fill out a form.
Yeah.
What, the DIR or the PPD?
Yeah.
A-list.
The big A list, you have to file an application, you have to file an
So
application with it.
basically just following the application.
Yep.
Yeah.
I mean, think about it. You're a doctor licensed under Nevada law to perform examinations and treat people. This is just an independent examination that you're doing under
And then you
this
choose,
act.
you choose your specialty that you're
So I'm
under.
assuming both sides obviously know which is a good doctor, which is, you know.
Trick question.
We may
I
not
hope
have
so.
the same
Trick question.
definition.
Well, it depends on what you define as good.
Or, you know, or are they copying a report from somebody else, you know? So obviously, you know, if you're writing a nice big report, that's a legal report.
Obviously, for an IME, I think both sides, we're looking for the most experienced, best qualified, experienced doctor that we can get. And so your IME doctors are going to be, I think, generally speaking, some usual suspects. And they probably tend to be the folks that are also the best treaters. So, you know, we got a limited small pool.
Yeah, they should be. And with regards to, you know, again, I'm old school, so it is not unusual for me to take a report and another report and put them up against to see if there was anything changed.
Oh, gotcha.
Because a lot of times, regretfully, they're not. And those are the physicians where if I get a request for an IME and it's Dr. Quackadoodle, I will call their attorney and say, look, you know, can we talk about this for a minute? This is going to lead to litigation. I'm obligated to give it to you. I'm going to give it to you. But Dr. Quackadoodle is going to tell us this, and then we're going to litigate it. And so a lot of times with that open communication, you can get it done.
Is Dr. Cut Everything not available?
Well, Dr. Cut Everything is a surgeon. Dr. Quackadoodle is a physiatrist, or something like that. They're different. So we do, I'm sure that who I say Dr. Quackadoodle and who Miguel says Quackadoodle are maybe not the same. But yes, we do, certainly the people who've been around for a long time, you recognize what you're gonna get. And sometimes when I get a request for an IME, I can call the attorney at that time and go, okay, you asked for Dr. Quackadoodle, you're looking for this, let's talk about it. And again, it goes back to what Carol says. If you have open communication, the ultimate goal in every claim is the same no matter who you're talking to. Doctor wants the person to get better, their attorney wants them to get better because that's how they get paid at the end. I want them to get better because I need them to get back to work and to continue.
And
So-
you need money in the market, not in reserves.
Right.
People
Right.
don't understand, those few attorneys on the other side that really somehow convince themselves that insurance companies want to harm their patients
Right.
don't understand how this business works.
Right,
I need money in the market, not in reserve,
right.
to pay for your claim. So I
Right.
need it closed as soon as possible.
And I certainly hope in theory that the only people in this process that don't have skin in the game are the adjusters. We don't get paid extra for closing, we don't get paid extra for low PPDs, we don't get bonused out for this, that, or the other thing. You know, I get a bonus at the end of the year if I clicked all my boxes correctly. It has nothing to do with anything that anybody else does. So that's important to realize too for us, is there are too many emotionally involved adjusters, and that needs to be checked. But if you're doing it right and you're communicating with everybody, you can stay grounded. Phew, that was tiptoe through that one. Okay, let's do some. Yeah, I'm trying. It's my new turn. Let's give away some presents. And you know, thank you so very much for you guys. And I know, Doctor, it took you a minute before we could get you to
That's
speak.
fine. I learned a
But
lot.
your
I
words
learned
are
a lot.
precious. Precious.
Appreciate all of it. Really good.
Yeah, thank you very much.
And can you write them down, anybody online that wins a card? Because, I don't know, it tends to get messed up and then people go, I won, but I don't know who I won it from and I
Okay.
don't know where I'm supposed to get it from.
I
So
got
just
pen and
wanna make
paper.
sure
I'm on my way.
everybody's
You
good.
as an attorney have the ability to look up their prior records? Or no?
Not
Do we have tickets? Where's the
if I have
ticket?
access to the
Yeah, that would be
system,
helpful.
or something like that. I can certainly get.
We
if they're
678-426.
available. Because these stocks are dropping records, you know, because based on their HIPAA requirements, they only have to maintain those records for only 7 years. So they're dumping. They're like, we don't want to have access. And that's what's the challenge.
That would be
But the
hysterical.
PPDs, they have to be
Yeah, well, the good thing is,
PPDs, they're like, I didn't need to resolution. Those aren't that renovated. Those aren't that renovated.
Generally, the other
So,
places they should use it.
all the yellow ones are
because
online,
they're supposed to keep them.
the blue
Sometimes
ones
it
are in
gets a little-
person.
When I get
If you have one online,
they're usually in there. I get that like.
most likely they're gonna mail it to you. If it's an e-card, they're gonna email it to you. So please listen online if you hear me say online, because that's gonna be somebody from you, and you need to know who it is. All right, and then you're writing them down too. All right. So our first gift is a $50 Amazon gift card from TBJ Consulting. Winner is Lila Khan, Travelers.
I'm not gonna get graded.
Lila Khan, just, yeah.
Okay.
I'll interpret it.
Dalton, now watch this.
All right, next one is a $50 Amazon gift card from
Are you a
the
bike?
Cancer
You're a
Center
bike.
of Nevada. Winning number
Hey,
is
I tell people all the time, sitting here smoking, but you need to get out.
678-482.
Bad for your lungs.
I'm trying to be good.
I like that. I need to get that on mine.
I know. I got to close my rings, you know.
I usually.
Our next one is a $50 Amazon gift card from Dr. Andrew Park at DOC. Winning number is 678-512. 512.
Yes.
There's not a great reason to benefit.
12 is,
Next one is a $50 Kohl's gift card from Figure 8. Winning number 678-441. 441.
Yes.
Sedentary job is terrible.
I just ordered a 16 desk. I'm trying to be good.
Those are good. The evidence hasn't been, the literature doesn't support it yet, but I just don't think studies are that great. If you look at the ergonomic literature, they're
Our next one
I
is
think
a
100%.
$25
Even
Ulta
say
gift
no.
card from
They're
Dr. Colby Young, Jones,
No, they're
Fidel.
cheap.
Yeah, but
Okay,
you
so
know
it's hand
what?
surgery
gotta stay in your
specialist of
desk.
Nevada, $25 Ulta.
No,
Winning
not
number
the treadmill.
is
We banned those from
678
People can
440. 440.
Ulta, yes.
Yes!
What about the? I don't know, double check your numbers.
No, the cheap one we're trying to motor in there. It's like a treadmill.
2024, y'all.
You're like, no. You're like, no.
All right, our next one is a Marshall's gift card, $25 from Dr. Michael Schneider. Winning person is online,
Good old Larry.
Christina Heron.
We need to take it.
If you've never met him, he's a hoot. He's a special.
Or Ann, either
You
one.
do, Katie. She's very responsible.
All right. Is she though?
Yeah.
No, she's not. The next one is a $25 Kohl's gift card from Bone and Joint Specialists. Winning number is 678-510. 510.
That's Trudy.
True.
Oh my gosh. I could share it.
All right, the next one is a $50 Cheesecake Factory gift card from Simon Med. Winning person is.
Segovia. I will be out of the office the remainder of the day.
Oh, thank you, Denise.
Mrs.
Have a
Segovia.
great afternoon.
Yeah. Wow, jeez. It's Wednesday, leaving out 11:53. Dang.
Simon Med Online, Brenda Cotton.
Oh, hi, Brenda.
All right, our next one is a $50 Best Buy gift card from Kelly Hawkins Physical Therapy. Winning number is 678-480.
Still wrong.
480.
I can turn your 3 into an 8.
480.
In person?
678-480. It's in person. Oh, that's Dr.
Oh.
What?
He's looking.
Oh, are you? Oh, I thought you were.
No, I don't have
Go
one of
once,
those.
twice.
I would give it away. It's not.
$50 Best Buy gift card from Kelly Hawkins. Winning number 678-425.
No.
Oh.
Wow.
Okay, that's close.
Nice.
That seems rigged.
That's close.
Hey.
That'll work.
So these are all my kids' birthdays.
Are they?
417,
Nice.
417, 419, 425.
We do have a lot of
always remember the day before Hitler.
All right,
Today is my mom's birthday.
our next one
But
is
she
a
passed
$50
away.
Amazon
She
gift
would have
card
been
from
117,
TBJ
so.
Consulting. Winning person, Marisa Garcia online.
Well, happy birthday to her.
Next one is a $50 Victoria's Secret gift card from Trish Gibson Marketing. Winning person, Bernadette Gerlin.
Anything, please. I put myself on back. So text me, like, I understand individual cases, but if anything, any issues you have or anything that I could do.
This is a $25 Amazon gift card. Winning number 678416.
Hey.
Informative. Anything I can help with.
416.
There you go.
Make it bad. Oh, thanks. Likewise.
All right, this next one, same thing, $25 gift card from SCS Med Legal. Winning number 678449. 449.
My firm does this stand towards.
449. Once.
No,
Twice.
I think that
one's mine.
Wasn't it?
Think it's yours?
It was basically
No?
everybody who was with us.
All right, next.
That's in February.
That's a new thing.
All right, winning number is 460.
So it's kind of late.
Yay! I just needed a couple of
Law enforcement on the treaty side. I get that, that's fine, and I just like random, I didn't want to
This one is a $50 Amazon gift card from TBJ Consulting. Winning person online, Karen Jackson. Karen Jackson.
I think Dan likes to refer to me as Master of All.
I have a $50 Amazon gift card from TBJ of Nevada. Winning number
I've never
is
actually, I've only met him,
503.
like 6 years ago for work comp. Yeah, for work comp. The guy went to see our place and went to prison.
Maria, this Maria. I'll check when I get to the office.
Next one is a $50 Lowe's
The whole
gift card.
discussion is, do you know this person? Nope.
$50 Lowe's gift card for, from AMG. Winning number is
If that's something that you
470. Right here.
I'm happy to discuss it. Anything I can like say. Freddie, no matter
All right, the next one is a $50 Bath and Body Works from Capital Boat Consulting.
as well, and Henderson Police, and I love being out there with them. That's what I do. I say my name.
Dan, Toby, and Lisa, those.
Yeah, exactly. I just want to get better. I want to see them on the street.
Part of somebody, me in person.
I like the intellectual challenges there, even I love a housekeeper from head to toe. To tell people like, just
All right.
try to figure out.
This one's a kind of a bigger
We
one.
just want somebody.
This is from Crystal Cardoso. She is a beauty guru. She has a med spa. It's a $200 gift card to her med spa.
Ooh.
Winning number is 436.
I agree. I would love to see it here. I even asked.
Oh, this one is?
I wanted the Department of Administration to
Okay,
see it.
so the winner of the
Both
Bath and
sides
Body
need
from
to
Capital
agree
Boat
with it, and I
is
would- I've actually asked them to see
Abrela
pictures,
Nagon?
Love to see one, but I get both sides on the great side.
All right, this next one is a $50 American Express gift card
I love learning.
from Central Wellness and Pain Center. Winning number is 494.
I love learning.
494.
Way more than you. This 21-day thing.
Like my MA or, yeah, my front office girl, they speak, Spanish.
All right, I have a $50 Home Depot gift card from Dr. Amit Durek. Winning number 506.
You know, and I don't want, I mean, there's things coming back telling me that. Right, because there's different dialects for different Spanish people, so I just, what's the liability, like, if my stuff misinterpreted something that he put in there.
All right, next one is a $50 gift card to Lazy
So now
Dog.
we're trying to tell them that, okay, well, now you need to bring somebody to help interpret, so they can
Online.
interpret.
I haven't dealt
So this is,
I thought
it's
it's
from
that-
First Medical Advisory Group, it is a company with a $25 Starbucks gift card.
So what about if I have a patient, if we don't have one? Well, if I don't have a staff that doesn't speak Spanish? Depending on if I do 140 or 125. You can decline the IME or you don't have this to bring something in.
Winning number 481, 481.
I'll listen to you. I saw that.
You know.
I'll listen to you.
Oh, it's me. Oh.
Okay.
So I haven't had something like
So we will do a $25 bowling joint specialist gift card for
So
you.
make sure you look at it.
Right, no, I get it.
What it does is
All right, here's the tumbler again with a $25 EGC.
Yeah, I've never seen it. I just like, I say, because I know it came up with a question.
485.
Yeah.
486. Let's do it
Because
again.
I'm like I said,
Literally
because
is,
sometimes, you know, people are defensive and stuff, and they're like, hey,
I'm gonna
because some things go in there that they don't want to know about. And I'm like, well, I don't know what your liability
you
is.
can't say,
I don't know what my
if you do
office is
say
liable
that,
for, but I don't know.
you're then interrupting, and then you're subject to. So, and I don't like it.
The office I work for, were sent clients,
Okay, I have a $60 Amazon gift card from Hampstead, Nevada, on line.
I feel that he don't
Adam
do
is
the
gonna
right
pull
job.
us out of the cloud, and
He's
it's
like,
gonna
I can't see
become
my we get
a
some
particle.
You can always do that.
Right, so
Right,
you
and
cannot
I don't
look
want
at
to,
something
but I
that
just want to
affects
make
it.
sure,
So when
I
you've
mean,
got
if
somebody
they're
who-
I don't want their job liable that I don't know.
And I allow one.
And for an IME is different.
That's the other thing
So
that
Center
happens.
for
When
Wellness
the
and
when
Patient
the
Services
training doctor has
$100.
translated,
Interpreters,
put my ticket back?
Yeah, I transferred money, a $2 bill. All right, ready? Winning numbers.
And with some related.
6, 7, 8. 5. 1.
Subrogation.
2 more.
What? Rigged.
Hey, thank you very much. We appreciate you guys. We'll see you in a couple weeks, couple months.
I think that's it, right?
What do we got next?
What do you mean?
What event?
Presentation.
724. Next is 724 PPDs.
Okay, 724 PPDs. Case studies. Okay, PPDs.
Hey, Ann,
Thank you.
can I get license credit in CEUs?
Yes.
Oh, okay, I didn't know. I was like, I just renewed, but you know, I like to be
I
proactive.
know you probably got 42 at the end of the time.
Girl, you know I always have more.
I know.
Because, you know, I gotta know.
That's, you know what, and you do know. That's what happened. That's right.
See your name all the time on the PAO, and it's nice to see.
Well, Dr. Kuchera, I will see you next Thursday. You're my buddy now, so.
Yeah, you're my bud now.
He's my buddy now. Well, he's gonna help me out with my PD. Yeah.
What do you mean? What do you mean? What do you mean?
We're working on nutrition for my police force. Yeah. So he's really active in like SWAT activities and things along those lines, and wants to support that. So hey, and he'll be culturally accepted. So you know, we gotta do what we gotta do. Cause you know, did you hear?
What?
Well, it's not publicized yet, but City of Henderson won the National
that's the way it always is.
Theo Award.
I didn't play it.
Yes, yes, I did. I know.
You know what? Carol, that is awesome.
I know.
It's so deserving.
Oh,
It is because no, it's not just because it's because of the way you work. That's outstanding.
Well, you know.
It's great.
No, I'm joking.
I know.
I was
it's
so
great.
happy though,
It's
because we
great.
didn't think, because you know we just implemented that program, so we didn't think. But you know, I said, hey, let me take a stab at that application and
It
submit
shined
it.
above all
And
the
we
rest.
won. I'm so
Yes!
excited. So
That's outstanding.
yeah.
So what is it that
You know, National Comp, it's a large organization for risk and insurance, and so they have an award that they award annually to employers or TPAs that are innovative in their approach to addressing work comp claims and things along those lines. So we submitted our application this year and we won. So I'm excited about that. Yeah, they haven't officially noticed it, but yeah, so we'll get to be a speaker at the conference and they'll write up articles about it. So, as soon as they say we can officially announce it, then I will. Because you know, you think about it, for work comp at the city, for a whole year I was just 1 year by myself, and then it's just two little folks. So with two little folks, we made, you know, national headlines. So I'm excited about it. So I recognize you. I hope. No, I joke. I know. Oh, thank you. Oh, well, I just want to make sure. You know what? We have so many adjusters out there that act like they're scared to do their job. And that's why we're getting all these bad calls, because they're not doing what they should be doing. And now people are getting very adversarial, and all these different layers, all of this is making our jobs more difficult. And we gotta work together. We gotta work together. You know, I don't know.
And that's really what this
Well, hey.
But yeah, no, I agree with you entirely. Do you still think
Yeah. But at the end of the day, we gotta get the work done. So let's find a way to get it done easier. You know. But always good to see you, and I love looking at those babies online.
Carl fiance Lauren started in my law practice with me when I served as my partner. But then she had to leave the practice because her health fell apart. I interviewed her. I can't have my partner being a work comp lawyer, so she left to go practice. She's doing med mal stuff. She does PI defense for a big med mal discussion. So, but yeah, it's just an interesting call came from my client. She worked with me as an attorney, and I introduced them. And after we become partners, they fall madly in love.
Oh, literally, we're talking about observers, escorted. I was looking at that. That's not funny when I talk about that. And escorted her to the place now. He's getting a good relationship with her. I'm like, Carl, I want to be effective at that time. I was like, okay,
text you the number. I said, don't ever hesitate to reach out.
Awesome. I'll text you at the number you gave me so
Okay.
you have mine.
Perfect.
You just reply to that. We'll have each other.
Anytime. Say what.
Yeah, and I'd love to have you come talk to the team.
I'd love to go, you know, like all the time.
That's a good idea.